Okay, we are back in open court for day 2 of sentencing hearing. State of Iowa versus Jeremy Goodale, Jefferson County case FECR 005144. Dr. Cunningham was testifying when we broke yesterday, and Dr. Cunningham, you may come up, and we've got the mic on for you, so once you are seated and comfortable, we'll let Mr. Cook proceed with his questioning.
Now, Dr. Cunningham, what is the next psychosocial adversity impacting Jeremy's functional maturity?
The next factor was social divisions in school and community.
Which of your findings addresses this psychosocial adversity?
This is finding 4. Jeremy Goodale's functional maturity was adversely impacted by social divisions in both his school and community experience.
Does your discussion of this factor begin on page 41 of your report?
It does.
Please briefly describe this finding and how it relates to Jeremy's functional maturity.
Certainly. So a primary task of adolescence is identifying with the community around you, with valuing people who are not your blood kin. One of the ways that you do that is by identifying with and feeling a part of that community. As there are divisions in that, then that undermines that identification with the community as a whole. And so then makes you more vulnerable to act out against those members of the community that you're not experiencing as like part of the folks that you belong to. In Jeremy's school experience, as he attended the Maharishi School, there was some social division between those that were fully private paying in their tuition and those like the Goodale children that were receiving scholarships, where there was a sense of discrepancy in the way that they were treated or even who would play with them after school. Then there are also divisions in the community between the regular community kids and the Rue kids, or the kids that were going to the Maharishi School, and some division larger in the community between those that followed the Maharishi movement and those that did not. As Jeremy is kind of incompletely identified with the Maharishi group, it created an additional challenge in identifying and experiencing a reciprocal sense of social obligation to folks that were more broadly placed in the community. This was aggravated by many of his father's stances about never being pleased with any of Jeremy's school experiences, or those administrators, whether at the Maharishi School or in the public schools, being broadly against many general societal experiences or expectations. He was anti-vax, anti-woke, anti-all kinds of things. Now, as he expresses those opinions, part of what he's doing is identifying that the larger community is not something that you identify with. It's alien and even malevolent. Now, that's an unintentional effect in terms of its impact on Jeremy's social identification and development of kind of community morality, but it has impact nonetheless. And so those social divisions that he's experiencing himself between the Maharishi movement and the community at large are aggravated by a much broader sense of alienation that Dean experiences and is very vocal about with the larger community.
Dr. Cunningham, in addition to neurodevelopmental deficits and psychosocial adversities, what was the next arena of maturity delaying factors in Jeremy's childhood that exacerbated the brain immaturity shared by all 16-year-olds?
That was psychological disorders.
Which of your findings addresses this psychological disorder arena?
This is finding 5. Jeremy Goodale suffered from a mood disorder from his pre-adolescence, additionally challenging the progression of functional maturity.
And to assist the court, does your discussion of this finding begin on page 42 of your report?
It does.
Dr. Cunningham, what symptoms of a mood disorder did Jeremy exhibit from his preteens to the weeks and months preceding this offense?
So from his very early adolescence up through the weeks and months preceding this offense, Jeremy suffered from a mood disorder. And consistent with the cyclic nature that mood disorders have, he experienced a cycle of symptoms. Typically, these symptoms would last a month. The cycle might be as rapid as being depressed for a month and then feeling better for a couple of weeks and then being depressed again, or it might be some months in between those cycles. During those times that he was in this depressive phase of the cycle, his mood was depressed, he experienced feelings of futility, he was irritable and was easily frustrated, a very common adolescent expression of mood disorder. He suffered a loss of motivation and interest, except maybe for video games and smoking weed and kind of walking around town with just a few friends. He was easily fatigued. He was interpersonally withdrawn, except for just a few interactions. There were very intense feelings of self-blame and self-recrimination, feelings of worthlessness and failure, periodically accompanied, as I testified yesterday, by meltdowns of self-recriminations. You're so stupid, you're so worthless, nobody likes you, those kinds of things. He experienced social anxiety in a social situation, believing that he had said something stupid that other people were reacting negatively to, then the kind of self-recriminations, that was so stupid, why do you say that? Folks know you're a nerd. This kind of self-recrimination in a social context that inhibited his interactions there. He was also experiencing a sleep disturbance, another vegetative sign of a mood disorder. His escape was into video games and also increasing his marijuana use as kind of a self-medication to relieve his social anxiety and the broader experience of depression. He had passive thoughts of suicide. That means that kind of thoughts of, I wish I wasn't here. It would be better to be dead, that sort of thing. And then, as I described, he'd have these periodic meltdowns, anywhere from every few weeks to every few months, of these bawling spells that would last for 2 or 3 hours while he's got himself locked in his bedroom or his room with his sobbing and self-recriminations and very intense feelings of futility and worthlessness.
Dr. Cunningham, how does the presence of a mood disorder affect the risk of violent crime among adolescents?
It's a significant risk factor for violent crime. There's a very large-scale study, almost 60,000 young people. There were 3 longitudinal cohorts. In other words, there were 3 groups that were followed over time across their adolescence and into early adulthood. And as good research does, they then controlled for the influence of other factors. So they controlled for parental criminality, which would be a risk factor for teen violence. They controlled for child maltreatment, things like abuse and neglect. They also controlled for conduct disorder, which is a more severe and chronic kind of childhood misbehavior syndrome. So they controlled for those other factors that might be associated with teen violent crime so that you could distill out just the effect of what mood disorder was causing. And using a regression analysis, which is a way of controlling for those other factors, they identified that there was between a 1.7 and 2.1 greater incidence of violent crime among adolescents and young adults with a depression diagnosis. Now, they didn't all, of course, be violent, but you've got this increased incidence that's significant. And among those whose depression was bad enough that they were put in the hospital, there was an almost 3 times greater incidence of violent crime among those young people.
Dr. Cunningham, what's the next arena of maturity delaying factors in Jeremy's childhood that exacerbated the brain immaturity shared by all 16-year-olds?
So the next factor is substance dependence.
Which of your findings addresses this maturity-related, maturity undermining factor?
This is finding 7. Jeremy Goodale's functional maturity was further delayed by marijuana dependence and other substance abuse from his early teens.
Does your discussion of this finding begin on page 47 of your report?
It does.
Dr. Cunningham, before you describe Jeremy's teen alcohol and drug abuse, what are the risk factors for alcohol and drug abuse?
So the risk factors for, the primary risk factors are 5. The strongest of these is genetic predisposition. In other words, that there is a family history of substance abuse and or mood disorder in your family system. If you have a first-degree relative, that means mother, father, brother, sister, who is alcohol or drug abusing, then you're 3 to 5 times more likely to end up being drug abusing as well, or substance abusing of some sort. And of course, I displayed in Jeremy's family tree that family system is replete with histories of alcohol and drug abuse, as well as mood disorder. Attention deficit hyperactivity disorder is another risk factor for substance dependence. That's also present in Jeremy's history. Mood disorder is a risk factor for substance dependence. That also is present in Jeremy. Modeling of substance abuse and dependence was occurring both among his peers and also among his siblings. And then he was aware that his father was buying weed from the same person that Jeremy was buying weed from. And then finally, developmental trauma or instability. Those are experiences that would create internal emotional pain that a teenager or an adult would seek to medicate by using substances. And Jeremy spoke of the relief that he got from his anxieties and depression by smoking weed.
Dr. Cunningham, of the factors listed here, which is the most powerful, if any, in terms of who ends up with an alcohol or drug problem?
The genetic predisposition.
Which of these factors for alcohol and drug abuse were present in Jeremy's background?
All of them.
Dr. Cunningham, can you please detail for us what you learned about Jeremy's drug and alcohol use from his early teens?
I can. So he started out in 7th grade smoking marijuana on the weekends, on Saturday and Sunday of each weekend with a peer. In 8th grade, that escalated to smoking marijuana daily after school and all day on weekends with peers. Then in 9th grade, again with peers, he was smoking marijuana before school, at lunch, after school, and on weekends. And then in 10th and 11th grade, he continued to smoke marijuana daily. He used mushrooms or acid twice a month with Chayton. And then he was binge drinking twice monthly at parties with other teenagers. Other times he would binge drink by himself.
What are the implications of routine drug abuse and episodic heavy drinking in teen years?
So there are a couple of primary impacts that are negative. One of them is that substance abuse is altering and interfering with this rapid growth in the brain systems that are developing across your teenage years. And so as someone is abusing substances, that's interfering with that process and even resulting in some malformations as a result of it. So there is a physiological developmental component to heavy substance use during the teens. Additionally, the discomforts and struggles that all of us recall about our teens, those experiences were in fact developing emotional muscles that we would use to cope with stresses both at that time and later in life. As this young person is anesthetizing himself, it's not unlike what happens if you put your arm in a cast. You take the cast off after a couple of months and those muscles have atrophied. And that's part of what happens with substance dependence during the teenage years is those emotional muscles are not developing. This is recognized in the recovery recovery systems and treatment. In AA, those AA meetings and step studies are not about just helping this person remain sober, not drink, but instead are intended to help them develop the emotional muscles and progress in their own internal maturity in ways that have been arrested by that substance dependence. So in AA, someone may talk about being 40 going on 14. That means they're actually 40 years old, but they started drinking and drugging at 14 and kind of arrested developmentally at that point. And so now they're working on developing those systems. So even apart from acute intoxication, we're concerned about somebody that has an ongoing pattern of substance dependence because of that atrophying effect that it has. So when I get ready to fly back to Dallas this evening, I'm not just concerned that my pilot is not under the influence as he steps into the cockpit. I'm not happy if he's substance dependent, even if he happens to not have anything in his system this evening, because of that effect that substance dependence has broadly on judgment and reactions and attitudes and all kinds of things.
Dr. Cunningham, I noticed we previously skipped one of the psychosocial adversities impacting Jeremy's functional maturity. Do you know which one that one is?
Yes, I do. We delayed talking about the effects of the pandemic.
Why did you separate the discussion of the pandemic from the other psychosocial adversities?
Because the effect of the pandemic was to exacerbate Jeremy's mood disorder and also his substance dependence. And so before we talk about the pandemic, it's necessary to talk about those two sets of symptoms and disorders that ended up being aggravated.
Dr. Cunningham, which of your findings addresses Jeremy's experience of the COVID-19 pandemic?
This is finding 6. The social isolation of the pandemic exacerbated the family dysfunctions, disrupted Jeremy's adolescent development, and destabilized him.
Are your findings on, is your discussion on this finding, does that begin on page 43 of your report?
It does.
Dr. Cunningham, you've prepared a flow chart to aid in your testimony about how the pandemic impacted Jeremy in exacerbating other vulnerabilities, dysfunctions, and disorders. Is that correct?
I did.
Can you please use that chart to explain this impact?
Certainly. So before the pandemic, there are a number of vulnerabilities that are interacting with each other in Jeremy. He has ADHD. He is socially isolated as he grows up out on the farm, and then is also experiencing the social divisions within the school and community as well as his father's attitudes. And then he's also experiencing the deprivations within the family system, all of those factors that I testified about yesterday. Those are synergistically interacting with each other. Those are exacerbating each other and end up producing both a mood disorder and also his marijuana dependence. So that's where we are before the pandemic happens. Then and of course the hereditary predispositions are contributing to both the mood disorder and his marijuana dependence, as well as other risk factors that I described. Then the pandemic occurs. Now, as that happens, there is a loss of social interaction that he would otherwise have at school with peers, and also a loss of structure. Now, because he has ADHD, he is particularly in need of the structure of a classroom and other students around him that are doing his work, and the teacher who's right there to make sure that he stays on task. Those are all additional supports that he is particularly in need of because of the ADHD vulnerability. So we've taken away the social interactions and the structure that's there. Of course, that aggravates the expression of those ADHD symptoms because he's not able to structure himself, simply doesn't have that capacity. So now as he is not doing his work, and as he's home all the time, then he has the family dysfunctions increase because Dean's reactions to him about that inability to structure himself are increasingly negative and punitive, with lectures, with guilt-inducing statements to him of, after all that I'm doing here, you can't at least do this. Or as Jeremy is unable to do that, then Dean experiences that as a personal betrayal of him, that Jeremy has had this contract to behave in a certain way, which of course he can't do at that age and with the ADHD, that then is identified as his having been dishonest or betraying Dean and his expectations. So the family dysfunction and tensions are increased. And that leads to an exacerbation of both the mood disorder and his marijuana dependence. Really pushes him off track developmentally.
Dr. Cunningham, did you consider how Jeremy's immaturity may have been evident in his adaptive skill status?
I did. So Jeremy's immature status is quite evident if you simply look at the status of his life at the time of this offense, and that's my 8th finding.
Does your discussion of Jeremy's adaptive status begin on page 51 of your report?
It does.
Dr. Cunningham, without providing all the information detailed in your report, please illustrate Jeremy's immature adaptive status at the time of this offense.
So he's in his junior year in high school. He doesn't even brush his teeth every day, and he never flosses. He's never cooked a meal. He would recycle dirty clothes from his hamper. In doing his laundry, he never separated the colors and whites and would leave the damp clothes in the washer with some regularity where they would then mildew. He didn't fold his clothes, he just stuffs them in the drawer. Consistent with his immature status, he has a 9 o'clock curfew on weekdays and a 10 or 11 o'clock curfew on weekends. He's unable to self-structure himself in doing the online school instruction. What money he makes by working part-time on school holidays with the same construction company his father works with, he immediately blows on impulse purchases or weed. He'd never lived independently, never wrote a check, never paid a bill, didn't have a driver's license or even a driving permit, and Dean intuitively recognized that Jeremy was not mature enough to drive, and in fact with the mood disorder was even at some risk of potentially using that capability to harm himself. His longest romantic relationship since age 13, he had a little sweetheart in 7th grade, I think, for 6 months that we saw each other at school, and sometimes he would go to her house. After that, he had never had a romantic relationship that lasted longer than a month. He'd never been in love, still a virgin. His social development in that aspect of his life was simply very immature.
Dr. Cunningham, what was your next finding regarding Jeremy?
Finding 9, the effect of neurodevelopmental deficits, family dysfunctions and deprivations, psychological disorder, substance dependence, and the challenges of the pandemic and community schisms as well, rendered Jeremy functionally less mature than a normally situated 16-year-old.
Is this finding discussed beginning on page 54 of your report?
It is.
Dr. Cunningham, please illustrate this conclusion with the chart that we've been working through.
So earlier I identified that there are 4 major types of adversity that may interfere with the development of functional maturity. All 4 of these are present in Jeremy's background, and they serve to render him particularly immature as compared to a normally situated 16-year-old.
Dr. Cunningham, have you prepared a chart with a more detailed summary of the factors supporting this conclusion regarding Jeremy's particular functional immaturity?
I did.
Can you please summarize that chart for us, please?
Certainly. So we begin with the brain immaturity that all 16-year-olds have. And now we have these maturity delaying developmental factors that are present in his background. There are 9 primary family dysfunctions and deprivations that I reviewed. Then he also has a neurodevelopmental impairment, the attention deficit hyperactivity disorder. There are these social divisions. He has a mood disorder, There's a destabilizing effect of social isolation in the pandemic, and then he's marijuana dependent as well. And those result in particular functional immaturity in him, well beyond what we would expect to see in a normally situated 16-year-old.
Dr. Cunningham, what was your next finding regarding factors undermining Jeremy's decision-making?
That was finding 10, that Jeremy continued to abuse substances proximate to the offense and was under the influence during the offense. That further degraded his judgment and impulse control.
Do you detail Jeremy's substance abuse proximate to the offense beginning on page 55 of your report?
I do.
Dr. Cunningham, what did you learn about Jeremy's substance ingestion proximate to the offense?
So first, in the week prior, to get some sense of what his pattern was close to the offense, he reported that he was smoking an eighth of marijuana daily. The first thing in the morning, he would smoke either a THC vape or THC wax. Then he would get to school a little bit early and smoke marijuana with peers there. At lunch, he went to a peer's house and smoked marijuana there. After school, he smoked marijuana with another peer as they drove around. And then in the evenings, he was picked up by another peer, and they would drive around and smoke weed.
How about Jeremy's substance ingestion the day of the offense?
So he had run out of the THC wax that weekend. So his first marijuana of the day was while he is with Zoe there at the park just before this offense. And they smoked 1.5 grams over a 45-minute period just prior to the offense. So he subjectively identified that he was high at the time that this began. That night after moving the body, Chayton provided alcohol, and they each drank 5 cans of 9% alcohol hard seltzer. He knew the alcohol would put him to sleep, he described, and that's what he wanted after this offense. He wanted to be put to sleep and be anesthetized.
What is the implication of drug abuse close in time to the offense?
So these are acting to further degrade his general judgment and impulse control. He's already got these limitations that are built in. The effect of this is to further undermine that decision making. Now, it doesn't rob him of choice. It didn't deprive him of, on an absolute basis, of knowing that this conduct is wrong, but it did impact the quality of judgment and moral reasoning that he could bring to bear on this. The same quality that I would be concerned about in my airline pilot. If this is what his substance abuse is the week before he walks into the cockpit to fly me home.
Dr. Cunningham, what was your next finding?
The next finding was finding 11. The limitations of youth and Jeremy's particular functional immaturity are evident in his decision-making and behavior, both in the lead-up to the charge conduct and the operationalizing of it.
Is this finding discussed beginning on page 57 of your report?
It is.
Dr. Cunningham, have you listed on a slide the various factors in Jeremy's decision-making and behavior that are consistent with his particular functional immaturity?
I did, and identified 11 categories of those.
Could you briefly illustrate each of these?
Certainly. So first, misguided loyalty. That Jeremy places his loyalty to a friend over the obviously more significant moral and social imperative of someone else's life. That emphasis on pure relationship above all else is a feature of adolescence and also reflects his inability to discern proportionality of what his obligations to other people are. There are poor boundaries and limited ego strength. I talked about this some yesterday. This is not his problem. This is Chayton's problem. And yet he takes this on as his own. And has limited ego strength in being able to say, no, I'm not going to do that when Chayton first floats the idea to him. Or in the 2 weeks in between, having the ego strength to say, you know, I said I would, but actually, I'm not going to do this. And so his ego strength is not sufficient to tolerate the loss of face that he might have as Chayden viewed him. Then number 3, outsourcing of planning. A feature of adolescent decision-making that happens that you see in their involvement in criminal activity is they don't understand the law of parties. The law of parties means if you're along when a criminal act is done and are essentially giving consent to it, then you're up to your ears in everything that happens. So if you go into the convenience store with 3 other kids and to rob this, and one of them has a gun, and that person with the gun shoots the clerk, you're in this up to your ears, just like the guy with the gun. Adolescents don't get that law of parties. A part of their giving each other permission to experiment with different identities is you let somebody else do their thing, and that has nothing to do with you, even if you're alone. So Jeremy expresses this with the outsourcing of planning. Since this is Chayden's agenda, then we'll leave it to Chayden to organize and decide how this is going to happen. This mostly belongs to him. Yeah, I'm along, but I'm not really in it to the extent that he is. That's it. And so by so doing, he's expressing that failure to recognize the gravity of his own participation, as well as the gravity of the blowback from this. Not only the impact on the families involved and the taking of Ms. Graber's life, but the profound cost that this has every potential of causing in his own life. Then number 4, the synergy of immature persons. Consistent with youthful offending, this is done jointly with another young person. In fact, though, it's not necessary for another person to have been involved. Chayden could have affected this by himself without Jeremy's participation. But instead, 2 young people will join together to do something that likely neither one of them would have done by themselves, even though it could be done independently. Now, the significance of acting independently, if one can, is that as you participate in a joint offense, you have made a lifelong potential witness of your co-defendant, who at any point in time in the future, by making a report of this to law enforcement to get himself out of some difficulty, then brings your life down too. And so generally, you want to take care in involving people beyond who is necessary to actually affect a crime, because you're creating witnesses against you and co-defendants. There's also this joint degradation in judgment and impulse control that happens as somebody else joins in. This idea I spoke of yesterday, that 1 boy is a boy, 2 boys are half a boy, and 3 boys are no boy at all. Number 5, consistent with the difficulty that teenagers have in maintaining perspective about being cut from an athletic team, about a romantic breakup, about failing a class. Teenagers are notorious for not being able to maintain perspective about a problem. That sometimes leads to suicide, as they regard that their life is over because some transient disappointment has happened. That's part of what Dean was concerned with in Jeremy. And so this failing Spanish is a transient issue. And in response to that transient issue that everybody's life will go forward from, likely without much of a ripple in the long run, there is a catastrophic solution that is applied. That lack of proportionality about problem and solution is classically adolescent. There is impulsivity in this offense. That's the judgment impulsiveness that I spoke of yesterday, in terms of the ways in which, although it's planned badly and only up to the point of affecting the murder. There's rigidity and limited ability to generate alternatives about bailing out of this plan once it has been put in motion, once he's agreed to it. There's profound neglect of the risk of apprehension. That occurs as Chaden tries to recruit Dill before he approaches Jeremy, in Jeremy speaking to Zoe about, would you still care about me if I killed somebody in advance of this, in having Zoe there at the crime scene where she can tie you and Chaden together just before Ms. Graber is seen for the last time. In the reports that they're each making to peers about their participation in this. Jeremy pushes a wheelbarrow across town in the middle of the night, where if he's observed, somebody is going to clearly have a memorable recollection of that. So just all kinds of ways that they are maximizing the likelihood that they're going to be caught. And in fact, that's exactly what occurs. Within 12 or 16 hours, they're both in custody, which is a remarkably rapid resolution of a criminal investigation. There is lots of improvisation that occurs. Because it hasn't been pre-planned after the murder, now they're having to make it up as they go. One of the remarkable instances of that is that when they take Ms. Graber's van and they leave it park it in the trees at the end of a dead end, they walk out just a short distance, and then they decide, actually, why don't we call somebody to pick us up? So Jeremy calls Habib to come pick them up. Now we've brought Habib into this. That when the car is discovered, there's someone who knows that you were in proximity to that vehicle on the basis of kind of a lane story. That's an example of the improvisation that's occurring as they go. Even that they neglected to consider that the ground would be too hard, would be very hard and difficult to dig into. There are many instances of adolescent limited theory of mind. I referenced theory of mind yesterday. Theory of mind is the ability to anticipate what other people are feeling, how they will react to something, what their agenda is, even if they haven't expressed it overtly. There are two broad areas where Jeremy exhibits limited theory of mind. And theory of mind is something that develops progressively with brain development across adolescence and into adulthood. A couple of major arenas that he's lacking in that. One of them is that Jeremy has an adequate theory of mind about Chaden, about Chaden's agendas, about why Chaden is putting him into this, is involving him at all, or is putting him in the lead in things like bringing the tarp and the wheelbarrow across town, and seems oblivious that Chaden may be taking advantage of him or even setting him up to be blamed for this offense. The other area that you see as deficits in theory of mind is that he seems entirely oblivious to how his reporting this will impact other people. So as he tells John Burnett about this, as he tells his video game buddies, he seems oblivious to the horror that they will have at the thought of somebody having been murdered and knowing who did that. And that they will not just keep this a secret. That by their own adolescence, they're going to need to tell somebody, a peer, a parent, someone, or may feel compelled to come and inform law enforcement. And so there's a broad and recurrent failure to recognize how other people are going to put things together. That it will occur to Dill, gee, Chaden tried to recruit me, I should probably tell somebody about that. Or Zoe, my goodness, Jeremy referenced killing somebody and now we've got a teacher who's dead. That he wouldn't have anticipated what would seem to be pretty obvious, that this is implicating him. This is going to land on people. They will remember this. And then finding 11, that limited theory of mind is exemplified by his discussing the offense immediately with many peers. And that's also a feature of adolescence, that they experience themselves by bouncing their identity and their experiences off of other young people. And as they try to sound that out and get a sense of themselves by what they say. And so there's this compulsive need to tell, and he's exhibiting that as well.
Dr. Cunningham, are you aware of a comment Jeremy made to his sister Jackie 48 hours following this offense?
I am.
And I believe that's been referenced a couple of times here in our hearing over the last couple of days, and I believe it's been paraphrased. In referencing the transcript, I'd like to detail this exchange for you to see if it's consistent with your recollection. Is that right?
Yes.
Okay. Jacqueline asks or states, or maybe, are you sure you are just not in so much shock? That's why you're not freaking out, because you're in so much shock. Jeremy's reaction, I honestly don't know. I don't feel guilty. I don't feel remorseful. I don't, and then he trails off. Is that your recollection?
It is.
What, if any, immaturity is reflected in this comment?
First, Jeremy's insight about himself and his own reactions is limited, and was particularly limited at age 16. And so as he says, I'm not in shock, or I don't know if I'm in shock, we wouldn't take that as dispositive about anything. I don't expect Jeremy to know much about what his inner state is at that point. Even today, Jeremy can't explain why he was compulsively telling other people about this in the immediate after, other young people in the immediate aftermath of this. So his insight about his reactions is very limited. That's number one. Number two, there's a good likelihood that he is in shock. That this is a completely aberrant and catastrophic behavior as compared to anything that he's ever been involved in, and would be exceedingly difficult to process. And so I don't know how Jeremy is not in shock at this point, given what he has to try to integrate and make sense of. Number three, it isn't just that somebody is particularly functionally immature as they commit the offense, but 48 hours later in police custody, now it's like they're a 30-year-old. Now they suddenly have all these capabilities. No, he is still this particularly functionally immature 16-year-old going on something less as he is sitting there with Jackie. And a part of the limitations of that youthfulness is not fully appreciating the magnitude of what he's done and the implications this is going to have for his life and the reverberating effects in the community and the profound loss to Ms. Graber of her life. And so because he's 16, he doesn't get that. And we really wouldn't expect him to at that moment. Those are the things that we would expect to develop as he crosses, as he reflects on this, as his brain matures, as he progresses from 16 to 18 to 20 to 25, the magnitude and the full implications of this will be something that descend on him and will continue to do so over a decade following this experience. And so this does not indicate somebody who is irreparably corrupt and incapable of those reactions. Those are part and parcel of what's happening in the moment with the apparatus that he has at the time.
Dr. Cunningham, how did Jeremy's particular functional immaturity impact his moral awareness and reasoning about the offense?
Well, it did not keep him from knowing on an absolute basis that this is wrong. But clearly that functional immaturity was having profound effect on these moral considerations that are a part of moral reasoning. And so it reduced those capabilities. At 16, they're incomplete anyway, and they're going to be further reduced by his functional immaturity because of the factors I've identified. So he's going to have a reduced capacity to engage in in this sort of moral calculus.
Doctor, let me return to a concept that you discussed earlier. Would every 16-year-old with adversities like Jeremy engage in serious criminal violence?
No. You're going to expect someone from Jeremy's background to have a difficult teen progression. Their adolescence is going to be troubled. You've grown up, you have these hereditary predispositions. There's this very serious deprivation in your childhood. Your mom leaves you when you're 10 years old. Your parents are limited. This is somebody who's going to have some significant difficulties as a teenager. Exactly what form that takes is uncertain. His potential for this being reflected in criminality and criminal violence is much increased. But similar to our 100% penetration discussion, you wouldn't expect to see this in everybody. You'd expect them to be growing out tumors of some sort. Everybody's not going to express this in a violent way.
Dr. Cunningham, did Jeremy's particular immaturity make him commit this offense?
No, it didn't make him commit it. He still had a choice, but he had a choice that was inclined by his immaturity and the adversities that I've described.
What are the implications of your findings in this regard?
So very importantly is to recognize that as we look at that immaturity and adverse factors, that's the only apparatus that Jeremy has to use in decision making. It's not like we've got this particularly immature brain here, and then there's this little man in his head, what psychologists call an homunculus. But there's this little man in his head that somehow sits outside of all of that and decides what the right thing to do is, or what the best thing to do is. There's no part of him that sits outside the apparatus that he has. There's only that limited, impaired apparatus. So no little homunculus that's making these decisions. And that's an important concept to understand, that people are only able to use what they have. There isn't magically some other part that sits outside of that that's making the decisions.
Do you have an analogy that illustrates how choice is inclined by immaturity and adversity?
I probably do, but I can't think of it in the moment.
I think we talked about teen speeding on wet pavement analogy.
Sure. So let's say that you've got a teenager who is driving recklessly on wet pavement. Now that teenager is clearly making a choice about doing that. He knows he's driving a car. He knows the pavement is wet. He knows the traction isn't quite as good. He knows that he's speeding. There is at least an intellectual awareness that that could result in an accident. Now, he engages in that behavior anyway because he is limited in his ability to properly weigh that context. The severity of the accident that may occur and the injuries that may result to him or other people against the experience of speeding in the moment. So it's not that he doesn't have a choice, it's that he has a choice that is driven by this primacy of reward over risk, driven by a faulty risk calculus. If there are other teenagers in the car with him, then even the presence of another teen, whether they're encouraging it or not, just the presence of that individual further degrades the quality of choice. So that's what results in those fatalities, those driving fatalities, being so much higher for these younger kids or younger individuals. Not because they don't have a choice in the way they drive, but because they make defective choices out of impaired judgment that is part and parcel of their youthfulness and brain maturity.
Dr. Cunningham, of the factors specified by the Miller Court and adopted by the Iowa Supreme Court in the Lyle decision, which ones have your testimony addressed so far?
So my testimony has addressed A, the character and record of the individual offender and the circumstances of the offense. It's addressed B, the background and mental and emotional development of a youthful defendant. It's addressed C, a juvenile's chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate the risk and consequences. My testimony is addressed D, the family and home environment that surrounds the juvenile, no matter how brutal or dysfunctional. And E, the circumstances of the homicide offense, including the extent of his participation in the conduct and the way familial and peer pressure may have affected the juvenile.
Which factors remain?
The factors that I'm focused on next are the juvenile's potential for rehabilitation.
Dr. Cunningham, what's the rehabilitation factor? Well, was the rehabilitation factor the second focus for your evaluation?
It was. You'll remember there were 4 sentencing factors. I'm addressing 2 of those. And the second one I'm addressing is rehabilitation, or the potential for successful community reintegration.
And what is your next finding addressing Jeremy's rehabilitation?
So this is finding 12. Jeremy's pre-offense misconduct and offense participation had an adolescent onset. In other words, he wasn't a profoundly troubled kid in his behavior. Because of individuals that have adolescent onset misconduct have a better prognosis in terms of whether they engage in sustained criminality than the kids who have always been seriously behaviorally troubled from childhood and continue that into adolescence. That sustained trajectory puts them at greater risk. Because of maturational immaturity as a mid-teen at the time of the offense, even such serious teen misconduct is not predictive of the risk of offending after age 25 and cannot be assumed to demonstrate incorrigibility or irretrievable depravity.
Dr. Cunningham, is this finding discussed beginning on page 61 of your report?
It is.
What does research tell us about whether juvenile offenders continue to criminally offend into adulthood?
So the takeaway is that the vast majority of juvenile offenders, including those who commit serious crimes, grow out of antisocial activity as they transition into adulthood.
Can you please?
And this is part of what the Miller Court was describing about the character of a teenager is not yet solidified. And so you can't assume that the behaviors that they exhibit in their teens reflect some sort of fixed personality character structure in them. That character and personality structure is still under construction. And so as they obtain greater brain development, they no longer engage in this misconduct because it wasn't about their character, it was about their youthfulness.
Dr. Cunningham, can you please illustrate this research and tell us about its conclusions?
Sure. So one of the researchers that studied this is a psychologist by the name of Lawrence Steinberg. Steinberg has engaged in studies that were sponsored by the U.S. Department of Justice. One of those looked at 1,300 juvenile offenders and then followed those 1,300 offenders from their adolescent offending out into adulthood, up to 7 years after their convictions. And what Steinberg observed from this group is that the process of maturing out of crime is linked to the process of maturing more generally, brain development more generally, including the development of impulse control. That means putting the brakes on things that are a bad idea, and future orientation, being able to track forward into the future about your own behavior and your own outcomes.
Dr. Cunningham, how do these findings from Steinberg fit with prior research on whether adolescent offending continues into adulthood?
I seem to have disconnected. I know I'm back. So they're entirely consistent with a friend of the court, an amnesty brief that the American Psychological Association filed with the Supreme Court in the Miller v. Alabama case. And those findings, from historical findings that the American Psychological Association described, only a small portion of adolescents who experiment with illegal activities will develop an entrenched pattern of criminal behavior that persists into adulthood. That holds even for youth who commit very serious crimes, or the most serious crimes. And remember that this friend of the court brief is being filed in Miller v. Alabama. This is a teenager who committed a murder. So that's who the American Psychological Association is talking about, is even these youth who've committed the most serious crimes. And that's what the Miller court is addressing as well, as they talk about that because character and personality is not yet fully formed, and because of the effect of brain immaturity, you can't simply use this criminal conduct as a teenager to conclude that this person is somehow irreparably corrupt.
Doctor, what factors account for why criminality and criminal violence do not continue into adulthood for these juvenile offenders?
So there are several processes that are happening with enhanced brain development that account for why adults are so much less likely to involve themselves in criminal activity than teenagers. The first feature is temperance. That's the ability to control impulses, including aggressive impulses. The second is perspective. That's the ability to consider other points of view, including taking into account longer-term repercussions and consequences, and also to take the vantage point of others, of how this will end up, how you'll view this at a point in the future, how your family will view this, how the victim's family will view it, the effect that it has on the victim, that you have a greater capacity to appreciate the repercussions of an act. And the third aspect is responsibility. That's the ability to take personal responsibility for one's behavior and resist the coercive influence of others.
Doctor, can you please explain how a more mature brain specifically reduces the potential for criminality and criminal violence into adulthood?
I can. So as we think about the components, to break down further the components of these themes that I identified from Steinberg. Adults, and by adults I mean people beyond age 25 who have gotten fully adult brain development, they have more effective impulse control, but have better brakes. They have a more realistic appraisal of apprehension. Remember, I talked about the issue in committing a crime is typically not committing it. It's pretty easy. It's getting away with it. And so there's a more realistic recognition of that potential. There's a recognition of the long-term consequences to your own personal outcomes. And of course, Jeremy's decision-making in this regard has been catastrophic regarding his own personal outcomes. That for maintaining and serving a friendship with Chaden and maintaining Chaden's positive regard, that he has sacrificed half of his adolescence and a good chunk of his adulthood. And so that ability to see the cost develops with your brain maturation. There's an identification and empathy with potential victims, which was obviously sadly lacking here. There's a clear identity as a law-abiding and moral individual, a sense of obligation that you have to family and others, an identification of the larger community that we're all in this together, and an appreciation of the collective good, and a mature commitment to a religious or ethical system. And of course, any functional religious or ethical system is going to discourage and prohibit you from behaving in ways that are exploitative and destructive to other people.
Dr. Cunningham, what's your next finding addressing Jeremy's rehabilitation?
My next finding is that his misconduct in the early years of custody, the disciplinary infractions that he's had in the juvenile facility, as well as the assault that he had on this inmate in the adult facility, that those behaviors are relatively typical of Miller defendants. That said, he exhibits early indications of rehabilitation.
Is your finding in this regard addressed beginning on page 63 of your report?
It is.
Dr. Cunningham, what factors point to early rehabilitation and Jeremy making gains in his maturity?
Well, the first factor that is consistent with these Miller defendants is that when Jeremy comes into custody, he is not somehow magically 27 years old. He's still 16 when he comes into custody, and is particularly immature for 16. So we're going to expect to see demonstrations of that immaturity. And just as Miller defendants come into custody less than 18, they're going to have a number of years early in custody before they get out to 25 and beyond, where they're still immature, where their brain development is incomplete, and they are behaving in custody consistent with that. And so in his early confinement, consistent with that, Jeremy is involved in kind of a minor disrespect, minor noncompliance, very teenage-like in those displays. And then is vulnerable, as I described yesterday, to the influence and direction of an older inmate about how you go about addressing this problem of the guy who's celled in your area who won't take a bath and is being disrespectful and exposing himself. So first, important to have a sense of this is not at all unusual and doesn't have a long-term negative prognosis aspect to it. In terms of gains in his maturity that are evident, there is a declining frequency of disciplinary infractions. That even as he's moved from 16 to 18, there isn't the same frequency of kind of disrespect, oppositional kinds of things. He has expressed remorse regarding the offense. He took responsibility for it with a proffer that implicated himself beyond what was even necessary. So with his own words, Jeremy described striking Mrs. Graber with a bat, something that would not otherwise have been known, that he also had struck her, but for his saying that in his proffer. And this is a proffer that was regarded as candid by the law enforcement officers that were undertaking the investigation. And so there is evidence of a growth in responsibility as he describes this, even to his own detriment.
Doctor, are these behaviors that point to Jeremy's ongoing? Are there behaviors that also point to Jeremy's ongoing immaturity as well?
There are, and that's what I described in terms of his disrespect and noncompliance in juvenile custody, and this assault on another inmate, this fist assault that occurred in June of 2023.
And what is the significance of this assault for Jeremy's rehabilitation potential?
I think it has no enduring implications. As we think about parole recidivism in terms of who reoffends on parole, the focus is typically in the several years before release. Maybe if you're talking about more serious violence, in the 5 years before release. And so this is kind of like Jeremy had a serious reckless driving incident at age 16, and then he has a speeding ticket at age 18. What's the predictive significance that has for his driving at age 30? Well, not very much. Because of both brain maturity issues and because the best predictor at that point will be the preceding 3 to 5 years, not what happened 10 years ago, 15 years ago.
Dr. Cunningham, what is your next finding addressing Jeremy's rehabilitation?
that by a number of metrics, Jeremy has a high likelihood of adjusting to the community without criminality or violence upon release as an adult.
Is this factor discussed beginning on page 66 of your report?
It is.
Dr. Cunningham, in addition to personal observations of Jeremy, are there research perspectives that can assist in illuminating his likelihood of adjusting someday to the open community without reoffending?
There are.
What are these base rates?
Well, so these factors, the most important being follow-up data of other adolescent murderers who then were released to the community after serving an initial term in prison. And also data regarding factors that are associated with a greater or lesser likelihood of offending on parole based on general parolees, not teenage offenders, but just general parolee data. Both of these make use of what we could call the insurance company method, which is defining a group and then tracking them over time. So for example, when my oldest son turned 16, the car insurance premiums went up $1,000 every 6 months. That was based on the insurance company's experience with 16-year-old male unmarried drivers. So on the basis of that historical experience, they then set a casualty rate because that's the most accurate way of forecasting what's going to happen or what your likely risk is. In medicine, that's called prognosis. So if I go to the doctor and he identifies that I have a cancer, one of my first questions is, what's the prognosis? What's the 5-year survival rate of people with this diagnosis at this stage? And that 5-year survival rate, that group data, is the best basis for identifying what my outcome will be. Same thing with the automobile insurance industry in terms of those 16-year-old male unmarried drivers. So if we can, we want to find group statistical data because that group statistical data is the best and most scientific basis for identifying what our potential outcomes are in this case. Now, that kind of group statistical data is the primary foundation of the mental health sciences, of psychology, and medicine as well. It's based on group data that follows people, that examines then what symptoms coalesce into what disorders, what treatments have what percentage of treatment outcome. All of that is based on group statistical data. The primary group statistical data is called the base rate. That's the 5-year survival with this stage of cancer. That's the outcomes of 16-year-old male unmarried drivers. Or if we're doing a risk assessment, what's the outcome of similarly described individuals? Now, knowledge of the base rate, knowing what that base rate is the single most important piece of information that you can have to do an accurate assessment of what may happen in the future. This was first articulated, first described in the scholarly literature by John Monahan, who's kind of the father of violence risk assessment in forensic psychology. He first described this in a very influential monograph in 1981. So for a long time, for over 40 years, the base rate has been a primary metric as we think about violence risk assessment. So we have base rates that we can look at, most importantly, regarding Miller releasees, because those are the offenders that are most like Jeremy Goodale. They committed a murder in their teens. They then serve a term in prison, then they're released to the community, then what happens to them? Those are the most accurate to him. We could look at general parolees, but we have to be careful about that data because those are all offenders that committed their crimes beyond this less than 18 period. They committed their crimes when their characters were more formed, when they had a more established adult life status. So we want to be careful about using the outcomes about those adult offenders to inform a teenage murderer. But they do provide group data, at least about what some of the factors are that may raise and lower the risk.
Dr. Cunningham, what is the scholarly consensus regarding the role of group data in assessing future risk of violence in the future?
Most important piece of information you can have to do a scientifically informed diagnosis, treatment, or violence risk assessment.
Well, let's turn to that most important piece, the Miller releasees as it pertains to Mr. Goodale. Let's begin with research that has followed Miller releasees. Please detail the first of these studies and what it revealed regarding the risk and comparative risk posed by these offenders.
Certainly. So as we talk about these Miller releasees, the first study that I'll talk about is one that comes out of Philadelphia. This is a study that was performed by the Philadelphia District Attorney's Office. And they followed 174 Miller juvenile lifers. In other words, these were 174 juvenile offenders who committed murder and were sentenced to life without parole. Then the Miller decision comes down from the Supreme Court saying you can't automatically sentence a juvenile murderer to life without parole. There needs to be a consideration of their youthfulness and circumstances of the offense and their character and background, these factors that I described addressing in my evaluation. So they then had new sentencing hearings where they were sentenced to something less than life without parole, and 174 of these were resentenced and released. Of course, there's a larger group that were resentenced and not yet released, but 174 were resentenced and then released. In this 174, 62% had been convicted of first-degree murder, and 28% had been convicted of second-degree murder. In two-thirds of the cases, 64%, like this case, there were multiple defendants. The released lifer had been the primary actor in 82% of the cases. Their age at release averaged 51 years old. The range was from 35 years old to 68 years old. And then they were at large in the community after their release for 21 months, the first 2 years of their time in the community. Now, of course, that's not the rest of their life, but if they're likely to reoffend, it's more likely to happen within the first couple of years. So here's the outcomes of these 174. Only 6 of these defendants, that's 3%, only 6 had been rearrested. Now, that doesn't mean reconvicted. That doesn't mean a new violent offense. That doesn't mean they went back to prison. But 6 cases, they had been rearrested. The charges were dropped in 4 of those cases. The other 2 had new convictions, one for contempt and another one for robbery third. 174 offenders, released juvenile lifers, released to the community, 1 contempt, 1 robbery third. Now, so on an absolute basis, the risk is extremely low based on this initial follow-up, less than 2%. And then not for terribly serious violent crimes, a robbery third, but not a new homicide or that kind of thing. So what about by contrast? Well, we could look at homicide releasees in general. These are persons that were convicted of homicide and then released to the community after they'd served their sentences. And of those, nationally, 30% are rearrested within 2 years of release. So we've got 3% versus 30% for the folks that committed their homicides as adults. That rate is over 8 times higher.
Dr. Cunningham, what did this study conclude regarding Miller releasees?
So the study concluded that juvenile lifers can be considered low-impact releasees in terms of risk posed to the community.
What other follow-up has there been of offenders resentenced and released pursuant to Miller?
So another group that's been examined is out of Michigan, And there are 142 Miller juvenile lifers who were resentenced and then subsequently released to the community. Of these offenders, only one offender had been rearrested. That's less than 1%. By comparison, the 3-year reincarceration rate, not rearrest, but re-imprisonment, the 3-year reincarceration rate for general parolees in Michigan is 18%, almost 20-fold higher. The comparison 3-year reincarceration rate for offenders paroled from homicide convictions in Michigan is 8%, and that's like 10 times higher for the homicide offenders who were adults as they committed their offenses. So there's another study, quite consistent with that Philadelphia study, that indicates that Miller juvenile lifers pose a very low risk of reoffending in the community and are profoundly, disproportionately less likely to be involved in that than general parolees. Kind of the idea, if you're going to parole anybody, these juvenile lifers are the best candidates in terms of low impact on the community.
Dr. Cunningham, do you detail the general parolee base rates in your report?
I do.
What is your conclusion from these base rate data from Miller and general parolee research studies regarding Jeremy's likelihood of success on parole?
That he is likely to be among the most successful releasees.
Dr. Cunningham, is there another domain of factors to consider in doing a parole recidivism analysis?
There is.
What is that domain?
So those are dynamic factors. The ones I've talked about so far are those are kind of immutable. You're a Miller releasee, period. You're an offender of a certain age. You're an offender who has committed a certain crime. You have a certain number of adult arrests, that kind of thing. And so those are kind of fixed by history. There's another set of factors that can't be known yet. Those are dynamic factors. Those are ones that may be present or absent, may develop over time, that influence the likelihood of success on parole. Those dynamic factors, 3 of them involve what quality of kind of general social support programming is available. So that includes a social support system. That's why it's important whether Jeremy's family is still involved with him now, cares about him, and shows indications and promise of being involved with him well into the future. Because a social support system that you're paroled out into is an important factor in your success on parole. Of course, as we sit here today, we don't really know what Jeremy's social support system will consist of at a time that he's ultimately released to the community. We've got some promise about his siblings, but don't know with certainty what's going to happen there with his siblings and his father as well. We don't yet know what relationships he will establish in the community. Some inmates get married across the course of their period of incarceration. We simply don't know, as we sit here today, what that dynamic factor will consist of. Another dynamic factor is housing. Obviously, offenders who have some place to live do better than the guys that are homeless, that don't have access to secure housing. That's linked a little bit to the social support system that you may go out into, as well as what kind of programming exists for parolees that the parole system or different agencies may provide. That housing factor is also unknown at this point, although the family support that he has points to this being there for him. Employment. Parolees who get jobs and are employed do better on parole than those that don't have that involvement in employment. Jeremy has shown early willingness to be employed in his part-time construction work that was well received, but this we also don't know yet what will be in place for him in terms of jobs, what vocational training or additional education he'll complete in custody, or what kind of employment situation he would be paroled out into. And then finally, positive social orientation. Inmates that have a positive community identification, are coping effectively, are trying to live their lives in ways that contribute positively to those around them. Understandably, those inmates end up having more success on parole. Historically, Jeremy has had positive social involvement, before this offense. There are early indications of positive social orientation as he has taken responsibility for his participation in this offense, given a proffer, that sort of thing, made a religious identification with a Christian faith while he's been in custody. So there are early indications of positive social orientation. This, though, is also best informed by who Jeremy is at the time of release, which we can't entirely predict today. That will be obvious to a parole board based on his record and programming and that kind of thing, but it's one that can't be accurately anticipated today with the same certainty and evidence that somebody will have looking at him contemporaneously at that time.
So would it be accurate to say, Dr. Cunningham, that the most accurate determination of the pace of Jeremy's rehabilitation cannot be made today?
That's correct. At this point, we would be forecasting into the future about who he is in 10 years, 15 years, 20 years, whatever, 25 years, whatever it is. At that point, it won't be an anticipation of the future. They will have Jeremy's track record. That parole board will have his behavior in custody. They will be able to identify what his track record has been, what his social support system is, what his employment prospects are, how positive a social orientation is. They'll have contemporaneous data about Miller releasees, about general parolees. So there'll be better science and more certain knowledge of who Jeremy has become and what the pace of his rehabilitation was at that time, far superior to what we can forecast today.
Thank you, Doctor. I don't have any further questions.
Thank you.
Take our mid-morning break right now, 15 minutes.
is admitted at higher security.
I just didn't want this to create some issue where all of a sudden, you know.
I haven't filed anything.
Okay. So those have already been filed, so you don't need to do anything with them. So if you don't need to do anything
Okay,
with
I'm
it.
gonna look here.
Okay. Did you catch that? We didn't file it this week, all right?
But they filed into the docket, right? Let me look.
So when we filed it, it's fine. I filed it. Because when we filed your substance abuse evaluation, it's like so it's filed under the court order evaluation.
It is a higher security level. It's a 2. But those, so, right, so, okay, so I would just make record with the judge about that, when you e-file them, you need to admit it, right? And then when the judge actually physically comes up, we change the security level. So they'll come in from home and then I just set the security level. They're going to have to be as H and I under the extended tax. Because right now they're just in a court document. Without. You can file another one, but I have one right here. Yeah, this one might be out of order because I was using it on yeah, I mean either way, but yeah, you can definitely have it. If you don't need this one, we're not going to take it back. Is there any comments on that? You have to attempt to agree. Just upload it as it is and make a record of where you need to be admitted under yeah, whatever one of them or whatever. If it's laid like that and we do this management work, I'll say that those are admitted. But as a court order eval of the docket, that's not going to show up on the payroll for this half as H&I. So they're going to be like a separate time in our computer system. No, it's not. But yeah, we could just, it's just a click of a button and change the security level and that will be
We're just trying to make sure that it's not.
He was just giving me a heads up around and I knew this was what I was just looking at things like this. So I'm like, yeah, I mean, they don't usually experience, but still. They're usually most of the time. Yeah, I don't know if
that's fine. You ready, Laura? We're back on the record. Counsel, I heard it through the grapevine that there was some record that maybe counsel wanted to make regarding exhibits offered yesterday by defense counsel, which was Dr. Cunningham's CV and report. Is that correct, Ms. Jensen?
Yes, that is correct, Your Honor. So we filed Exhibit H and Exhibit I. Exhibit H is Dr. Cunningham's report. We would ask that that be filed at a higher security level than the remainder of the sentencing exhibits.
So you're asking that I be admitted at a higher security level, or both?
I is just the CV, and that's not necessary.
Oh, okay. So just H, higher security level. Any objection from the state?
No, Your Honor. Wait, stand by.
Judge, we have no objection to the request by the defense, and I do have a brief record on a couple of our exhibits from yesterday.
Okay, go ahead.
So we had introduced, let me find it, hang on. Exhibits 124, 125, and 126, which are photos that expose the body of Nohema Graber. I was advised that those are not restricted. I would ask that those also receive the same type of security level, given the nature of those photos.
And for the record, Your Honor, I believe that there was a request made in the exhibit list. There's a notation there to request that that be heightened in security.
So security level 1 allows the parties and not the public to view the exhibits. Are we requesting a security level 1 then? It's not, it wouldn't be open to the public, but the attorneys would have.
Correct, yes.
Okay.
Thank you.
So I will, and is that what is requested for H as well? Security level 1.
We'll have one other exhibit to add to that as well.
Okay.
I just noticed it's not noted on our exhibit list that the autopsy report should also carry that same security level.
And that's 131.
131, yes.
So by agreement of counsel, I will file security level heightened from 0 to 1 on defense exhibit H, and then states exhibits 124, 125, 126, and 131. Anything else before we begin with cross-examination?
No, Your Honor.
No, Your Honor.
Go ahead for the state.
Morning, Dr. Cunningham.
Good morning.
Just a couple of quick rehashes of your background here. You're a forensic psychologist,
Clinical and forensic psychologist.
one of 350 board certified in the U.S.
In forensic psychology, there are about 1,200 that are board certified in clinical psychology.
Texan?
Sorry?
You're a Texan?
By birth, yes, and spent most of my life there.
Okay.
How could you tell?
Active duty Navy?
Yes, on internship, and while I was there at the sub-base, so about 4.5 years of active duty and maybe 2 years or more of inactive reserves.
Did you go through like a commissioning program or academy, OCS?
I did not. I actually arrived at the Naval Hospital in Bethesda One morning, got a 30-minute lesson in how to salute and was sent to the uniform store. So I came on internship at an odd time of the year and did not have the usual military indoctrination.
Never served on subs then?
No, I did not.
Never served on submarines? All right, I'll strike that line of questioning then. You said you worked 240 capital cases.
So I testified at trial in approximately 240 capital cases. I've been involved in at least that many more where I was not called to testify, then have participated in well over 100 capital cases at post-conviction or federal habeas, maybe 60 Atkins cases.
I would presume those are all adult cases?
So I have worked in Miller resentencings and some initial Miller sentencings as well. Those were not death. That first set of numbers I gave you were all death penalty cases. There are many other murder cases that I worked in, some of them involving youthful offenders who were less than 18. Some were involving youthful offender considerations for offenders who were between the ages of 18 and 22.
Based on the facts of the case we have here, those are the kind of cases I was hoping to ask you about. Ballpark, how many youthful offender or juvenile homicide cases do you think that you've been involved in your career?
Perhaps 30.
Perhaps 30. And in that involvement, who typically hires you?
I was retained by the defense.
In all 30?
Yes.
Okay. And you testified in criminal cases here in Iowa previously?
One instance previously.
Could you tell us about that case?
You know, I don't remember the specifics of it other than it was another Miller case that was here in Iowa, but as I sit here now, I don't recall the name of the defendant.
You remember the county?
I'm sorry, I don't. I travel widely.
You remember the year?
Not specifically. It was about 2017, 2018. It's prior to the pandemic.
You remember where you were staying, the town?
I'm sorry, I don't. I can retrieve that data for you, but I just don't know off the top of my head.
It's fine. What's the hourly rate you're charging for this case?
So my fee is $360 per hour. I've discounted that for travel time. I only charge half rate for travel time. The standard rate is $360.
Could you give us a ballpark on how much you're billing the defense for your involvement in the Goodale case?
I don't have the number. At this point, I have about 125, 130 hours in the case.
Could you do some back of the napkin math on that?
So the total of that fee, if there were 130 hours, would probably be someplace in the neighborhood of $45,000. My approval in this case, the funding approval, was only for 60 hours. The defense may end up paying me for all my hours. It may be that I'm only paid 60 hours, which is what the original approval was for.
Thank you. Running through your PowerPoint here, picked up a couple of, I guess I would call them themes on your presentation. Is it fair to say that one of your themes is that young people are not fully mature by age 18?
That's correct.
When should the law hold somebody fully accountable for their actions?
Well, it's not an easy question to answer with precision. Somebody is accountable for their actions at the point that they are well, I guess even juveniles are accountable for their actions, but they're treated and sentenced under a different system. Miller defendants, even at age 16, are accountable for their actions in that they're going to be convicted and then will face a long-term prison sentence. And so they're being held accountable. In terms of at what point should an individual be sentenced as severely, that's really a function of this individualized sentencing of moral culpability and the specific deterrence. Those factors would indicate that somebody who's less than 25 is not bringing a fully mature brain apparatus to bear. And so in those terms, that is a consideration that may be brought to bear. For death penalty sentencing purposes, that offense date is at this point 18, although the American Psychological Association has filed amnesty briefs expressing concern with that because brain development is still so incomplete at age 18, and has encouraged reconsideration of that as a matter of public policy. Long answer, I guess I'd say that's kind of above my pay grade, but if we're talking about fully adult brain development, it would be after age 25, with the notion that this is not an either or. There is a steady increase in available resources between the ages of 18 and 25. And so the law may decide to draw a line at 18 or at 22 or at 25 as it gives public policy implication to this research of what resources you have available to you to make your decisions.
But in kind of reading between the lines on the theme I previously asked you about, if young people are not fully mature by 18, then somebody should not be held fully accountable for something that they commit, a crime they commit below 18 compared to above 18. Is that fair?
Well, they should be fully accountable and will be fully accountable. I think an informed sentencing policy acknowledges the resources that somebody brings to their decision making, including this brain development factor. So accountability is like you're found guilty and you face prison time. Then we have a determination of what sentence is attached to that. As that's psychologically informed, that involves that immaturity and other adversities, as well as specific deterrents. The court will have two other issues that it will also incorporate into a sentencing decision that I can't illuminate.
What would those other two be? That would be the retribution and the general deterrence?
That's correct.
Another theme that I picked up on was that young men are generally more violent than old men. Is that fair?
That's fair. And not just young men, teenagers. I don't really consider young men yet. Teenagers, mid-teens forward, are more violent than older men.
Fair enough. Doctor, you produced the slide deck presentation that we've been viewing here the last couple of days, right?
I did.
And did you help with the generation of the questions that were asked by the defense?
I did.
Okay. And when we say help, how much help would you say you provided for the writing of the questions?
Significant. I drafted questions that would elicit the information on each slide as a way of saving for the preparation time of my testimony. Sometimes the defense counsel deviated from that question, but my involvement was significant.
It would be fair to say that in a lot of the questions you wrote the questions and the answers.
That's correct.
Okay. And I did notice that a couple of these slides looked familiar. You've given this presentation before?
Some aspects of it. The research slides I've used before. The factors that are specific to Jeremy Goodale are original with this case.
So I took the liberty of Googling your name when I found out you were an expert witness on this case and found a number of YouTube videos that were very similar in the structure of their presentation. Are you familiar?
I'm not familiar with my videos. I have not watched those. But I would not be surprised if the organization was quite consistent, which is a marker of good science and sound methodology, that you approach things with similar conceptualizations and it's informed by similar science. So a heart surgeon does a very similar procedure from case to case as he's addressing a particular problem. That's the mark of scientifically informed practice, that there is consistency in methodology and in the underlying conceptualizations.
So your similar conceptualizations would be your, I suppose, your research-informed theories on juvenile brain development and how it applies to criminal activity?
That's right.
And then I presume that you get hired by typically defense attorneys to analyze a juvenile defendant and work that juvenile defendant's facts into your overarching umbrella theory of juvenile brain development and criminality?
That's correct. I would be happy to provide the same evaluation and analysis for your office or other prosecutors, but the phone doesn't ring. This science, I think, is not particularly helpful to what you may be asserting in a sentencing phase.
It's helpful for the defense.
Yes, sir. In this case, the science is more helpful to the defense.
You talked about Jeremy's untreated adult ADHD.
I talked about his untreated ADHD. He was not an adult at that time, but
Okay.
his untreated ADHD.
Was he self-medicating for this?
He was self-medicating with marijuana and other substances for this, in addition to other risk factors impinging on that use.
Heard some interesting testimony about what you described as judgment impulsivity.
Yes.
And I think, if I'm not mistaken, that is an impulsivity that is not necessarily an instantaneous impulsivity. It's more over a period of time.
That's correct. It's distinguished from reactive impulsivity, which is an immediate response to some stimulus or provocation with very little forethought. Judgment impulsivity may involve planning, but it is planning that is, it's stupid planning. It's planning that neglects potentially pretty obvious consequences and contingencies.
It's pretty fair to state that that's not limited to juvenile criminal defendants. Is that fair?
It's not limited to them. It's much more pervasive among juvenile offenders. It's kind of saying, so temper tantrums are not limited to a 3-year-old. An adult can have a temper tantrum too. Well, that's right, but they're normative in a 3-year-old, and they're unusual in an adult, and they are driven by different processes.
Well, I think it's fair to state that murder is uncommon in both juveniles and adults, but is it also fair to state that impulsivity is involved in a lot of homicides?
So you asked a compound question. So murder is overrepresented among younger offenders in this age 16 to 23, this period of immature brain development. And so it's overrepresented there. It occurs in persons that are older, but less frequently. That's number one. Number two,
I think my question was uncommon, though. It's not common for juveniles to kill, and it's not common for adults to kill, correct?
That's correct, but that's not a good metric for examining the role of youthfulness in those offenses. The disproportionate risk is our metric, not whether it's broadly uncommon in both.
Okay. Back to the question about judgment impulsivity. You said it does involve some planning, and I think your example was you meet a girl one day, you talk about your future for 2 days, and then you get married on Wednesday,
yes,
Thursday. How long of a period would you say would require be passed between the idea and the action for it not to fall under the concept of judgment impulsivity?
So it isn't limited to a period of time. The issue there is that you might have, there may be planning over a 3-month period of time that actually represents 10 minutes of planning repeated 50 times. Mm-hmm. So 2 young people may plan on running away together and talk and fantasize about that for several months. Mm-hmm. But it never proceeds beyond just the euphoric kind of, here's how we're going to get out of the house and down the street. So you can't evaluate judgment impulsivity solely on a metric of time. That said, the more profound the consequences of a decision, the longer period of time is best involved in consideration of that. And as you compress that time against the magnitude of the decision, it increasingly reflects a rush to judgment. It increasingly reflects judgment impulsivity.
Well, in this case, Mr. Goodale and Mr. Miller discussed killing Mrs. Graber 2 weeks prior. It's a little unclear what happened in the intervening 13 days, but approximately 1 day prior to her being killed, they stopped and surveilled her. And then Jeremy waited at the park for Chaden to show up on November 2nd. Is that your understanding of the facts?
Yes.
And it sounds like from what you just previously stated that it's not necessarily their planning that leads to judgment impulsivity, but their lack of follow through on getting away with it, so to speak? What to do after she's dead?
That's not entirely accurate. The essence of a plan is the entirety of the act and getting away with it. That, much again like our runaways, the issue is not how to get out of the house and down the street. It's how are you going to live after that? What happens to the car? What happens with the police? How are you going to support yourself? What's the longevity of this relationship? It's all these other factors that have not come into the plan. That's what reflects adolescent planning, is it's only up to accomplishing it and it neglects the long-term contingencies and consequences. That's what's missing from a teenage plan.
Well, Doctor, I think you testified a couple of times here, and I don't think anybody would disagree with you, that the act of the murder is not necessarily the hard part, it's the getting away with it. Is that fair?
That's right.
And Jeremy and Chaden did have some follow-through and some planning on, quote-unquote, getting away with it, right? They moved the vehicle, they brought some devices for disabling her cell phone, they returned to the scene of the crime to hide evidence and dispose of the body. All of those would show follow-through and planning on, quote-unquote, getting away with it, right?
So it's not that there was none at all. It was that it was inadequate. It put them at additional risk, and it required substantial improvisation. So it's not that it just wasn't there at all, but it wasn't there effectively. It wasn't there in a way that would maximize their likelihood of actually getting away with it.
They weren't good at getting away with it, basically.
Well, they were not simply not good at getting away with it. They neglected really thinking through that, and then their operationalizing of their efforts was so poor that they were apprehended within hours.
Agreed. In discussing Mr. Goodale's psychological issues, you bring up Mr. Goodale's father and his vaccine hesitancy for the COVID vaccine. Is that a suggestion that his ideation to kill Mrs. Graber was somehow associated in some way with that?
Well, not simply the opposition to the COVID vaccine. I described a multiplicity of factors impinging on Jeremy's decision-making about participating in this offense. I identified that an aspect of that was his being retarded or delayed in his social identification with the larger community, with his school, with this teacher being a part of his community in a meaningful way.
But that hesitancy was one of the multiplicity of factors?
Well, so as his father has broad and open antagonism and disagreement with all kinds of issues in society, and is openly promoting those to Jeremy, openly holds them in ways that create estrangement with some of his daughters. As he does that, he interferes with Jeremy's identification with that larger community. That now that larger community, those community values and mores are malevolent, they're conspiratorial, they're not to be trusted. You can't really depend on and be a part of that larger community because it's corrupt or misinformed. As that's being promoted to a teenager and to a child, it's interfering with that child's identification with that community and with the development of a reciprocal sense of social obligation. And so that's a piece of a factor that contributes to this. And that's part of what's so disturbing about this. That's the, my God, you killed this teacher who would otherwise seem to be part of a protected class even, at your school that you've had, that's a part of your small community where we all trust each other. And so there was a profound delay in Jeremy's identification with the larger community. And then I'm looking at how do we understand that? Where did that come from among these factors that are impinging on him?
Another one of those multiplicity of factors was his mood disorder.
Yes.
And was that impacted by his use of controlled substances, marijuana and alcohol and things along those lines? Is that the mood disorder we're talking about?
Well, the mood disorder is not his substance abuse. The mood disorder is his depression that's accompanied by depressed mood, feelings of futility, loss of interest and motivation, some degree of social withdrawal, passive suicidal ideation, periodic emotional meltdowns, that he has, poor school performance. That's the mood disorder. Now, comorbid with that mood disorder is a substance use disorder. Both of those he has a genetic susceptibility to. Those interact with each other. He is treating his mood disorder with the illicit substances he's taking. That, of course, is a poor treatment modality that further aggravates, exacerbates his life situation, his poor academic achievement, that kind of thing. And so that then potentially increases the depression. It's not an effective self-intervention and is in fact making things worse. But they are not the same thing. They are they're two mutually interacting disorders.
But you talked a little bit about the day of the crime, Mr. Goodale sharing some marijuana with Ms. Pentel.
Yes, for about 45 minutes, they were smoking weed.
Almost immediately prior to the act, correct?
That's right.
It's fair to state Jeremy was under the influence when he was involved in the killing of Mrs. Graber.
He was.
But you're not suggesting that this is any kind of defense or excuse to his actions, correct?
No, this is impairment on a continuum. This is not impairment that rises to a level that it causes him not to have a culpable mental state, but as a guilt phase issue.
Because I think you did
does have an impairment effect as a sentencing consideration.
Because you did state that it doesn't impact his ability to know right from wrong, right?
Not as an absolute matter. A 7-year-old knows right from wrong in terms of killing someone. It impairs the quality of his moral reasoning about that.
And diminished moral reasoning, sorry, let me rephrase that. Diminished moral reasoning does not eliminate any knowledge from right or wrong.
Well, that's correct. It doesn't render you stupid, that you just don't know what's going on in the world around you. But it does impact on the way that you relate and to that world around you and the reasoning that you bring to bear around the value system. So if he simply didn't know right from wrong, then he would be not guilty by reason of insanity and would not then be accountable for his conduct. Would be excused from it. He would be not guilty. So this doesn't rise to a level, his moral reasoning doesn't rise to that level of being not guilty. It does rise to a sentencing consideration in terms of his not having the moral reasoning resources that an adult would have. It also relates to his long-term rehabilitation potential, because then his moral failures here at age 16, because they're rooted in his immaturity, are not predictive of what moral reasoning he'll bring to bear at 25 or 30 or 35.
And hopefully that will be aided through the rehabilitative process in custody.
Oh yes, it will be aided by the passage of time, and as he participates in positive rehabilitation programming, then it will foster the development of those capabilities.
I don't know if you recall slide 97, but I wrote down some questions about the immaturity of planning, operationalizing, and the aftermath of the offense. Do you recall that testimony?
I do.
There were 11 factors that you talked about there.
Yes.
And not to generalize too broadly, but don't each of these 11 factors apply to pretty much every homicide defendant regardless of age?
I don't think that they do.
Could you just run through the list of 11?
Sure. So the first one is misguided loyalty. That you agree to participate in a homicide.
And just the list is fine.
Okay, so there's misguided loyalty. That doesn't apply the same. Poor boundaries and limited ego strength. That's different for teenagers. Outsourcing of planning. That's also more typical of teenagers and their law parties deficits. The synergy of immature persons, by definition, involves teenagers, as does their offending much more often involving multiple offenders as opposed to a single offender.
The wisdom of crowds.
Sorry?
The wisdom of crowds.
The wisdom of...
Crowds.
Well, no, sir, it's well...
Well, it's a joke. I mean, a group of people generally make poor decisions.
Particularly groups of young people do. And here we're not simply talking about a group, a crowd, but even the presence of one additional person, or that two teens carry out an act that neither one of them would have done independently. That's very different from adults and the way they approach their offending. A catastrophic response to a transient problem, particularly on this scale. It's difficult to imagine an adult determining to kill their Spanish teacher because they're making a failing grade. The offense itself screams that this is a very immature person making that decision with a catastrophic response to a very transient and minor problem. Impulsivity, particularly the judgment impulsivity here, as it only goes up to the act and really is largely improvisation thereafter. That also is not typical of adults who are not making a decision to kill in the moment, who've decided 2 weeks in advance to carry this out. The rigidity and limited ability to generate alternatives, that also is much more characteristic of youthful offenders as opposed to adults who may even shift gears in the midst of heading a direction in the face of new information. The neglect of risk of apprehension. As adult offenders engage in homicides that were premeditated, much of the effort is directed, perhaps most of the effort is directed toward avoiding apprehension. Improvisation is characteristic of youthful offenders beyond the act itself. Their planning typically only proceeds for 3, 12, 24 hours and doesn't pick up after that. Adults are much more long-term oriented as they look at those issues, and as a result have accounted for more improvisations. The limited theory of mind is characteristic of teenage offenders that don't grasp how this will land. Difficult to comprehend of an adult offender who not only would try to recruit a non-criminal civilian to commit a homicide with them, not a hitman, but a non-criminal peer to participate in a homicide of a known person, and then just goes down the road to recruit somebody else as if that first person isn't going to give evidence against them someday, and then calls several of their friends to fully confess within the first 24 hours in detail, not snapping to the fact that those people are going to end up in a policeman's office. So profound deficits in limited theory of mind that this offense and its aftermath stream about that we wouldn't see at all in an adult offender.
Well, you might apply all those stronger to juveniles. There's a lot of applicability to any kind of murder suspect in these theories, correct?
No, sir. Again, I differentiated as I went through them that these are particularly indicative of a youthful offender and are atypical of an adult offender. That's not to say that there may not be some adult offender out there who picks up a piece or two of these. But I would really challenge you to identify an adult offender who premeditated a murder 2 weeks in advance and exhibits these 11 characteristics. I just don't think that person exists.
Fair enough. Turning to the questions that Mr. Cook asked you about statements to Jackie Goodale on the defendant's lack of remorse.
Yes.
I think you testified that you don't think the defendant understood his own emotions or feelings.
He has limited access to his own emotions and feelings.
Doctor, are you superimposing your own estimate of his feelings for his own recorded statements?
I don't understand the question.
Well, we heard what Jeremy said, and you're telling us that you don't think that he meant what he said?
Well, I guess I would quote Henry David Thoreau, who says, "It doesn't matter what you look at, it matters what you see." To simply take Jeremy's statement at age 16, within 48 hours after this offense, with his limitations, and somehow treat that as being the same as if it was said by somebody who is 30. You're looking at it, but you're not seeing it. Because if you see it, then you see the context that this is in and what else is going on.
But he said what he said, didn't he?
Well, sure. So I've never disputed he said it. The issue is what implications does it have that he said it? And most importantly, does this reflect someone who is irreparably corrupt, who is incapable of remorse and recognition of how they've injured others? So we're really talking about of what diagnostic significance is that statement.
And I don't think anybody up here has said that Jeremy's irreparably corrupt. I'm pretty sure.
Well, that's the implication that by seizing on that as beyond just a statement by an immature kid in the moment, who still as immature as he was 24 hours before. To emphasize that is to implicitly give it some sort of larger diagnostic significance.
It's been a fair amount of talk about Jeremy Goodale's home life. Jeremy had a relatively large family, correct?
Yes, sir, by current standards. Not as I was growing up, but by current standards. You know, to have 5 kids is a big family.
Had a family who loved him, more or less?
I'm sorry?
His family loved him?
Yeah, I can't answer. It's hard to answer yes or no. So love is not either present or absent. Love is on a continuum.
Okay,
it's like IQ.
They're here today, a lot of them, right?
Sure, they love him as best they can through their limitations. They care about him. The love that they had for him was not expressed in functional ways that would optimize his best outcome. They loved him badly in many respects.
Okay. Jeremy always had a roof over his head. He wasn't homeless.
That's right.
Jeremy wasn't food insecure.
That's right.
Jeremy went to a private school for much of his life.
That's right. On scholarship for a part of it. Yes, he was in a private school.
Maybe Jeremy's home life wasn't perfect, but I would presume you've seen far worse upbringings and home lives in your profession.
I've seen different presentations of deprivation. I have not seen a lot of cases where autonomy was undermined in early childhood to the degree that was here. I have not seen very many cases where your mama abandoned you at age 10. So there are features of this that are very pathological. There are other aspects of it where it wasn't as if he was beaten. He was not sexually abused by his family members. There are things that I've seen that were not in this case, but there are things that are here that were destructive in their own way.
Doctor, are you uncomfortable stating that in your 500 criminal cases that you've been involved with, that you haven't objectively seen worse home lives than Jeremy Goodale's?
I'm saying that the effect of somebody's home life isn't easy to reduce into better or worse. I've seen home lives that were characterized by greater maltreatment. and greater deprivations of some sorts. This home life, along with the other risk factors, was enough to get us here. And that's always what's happened in these murder cases. Whatever the background is, ultimately, this is where it ended.
Dr. Jeremy Goodale's home life does not explain his murder of Mrs. Graber, does it?
I think it's an important part of the explanation. It didn't make it happen, but it is part of the trajectory that put him at risk and does significantly explain his participation. I guess conversely, if it doesn't, then what does? If his home life, his ADHD, his substance abuse, his mood disorder, if those don't explain why he agreed to Chaden's request that he help him kill Ms. Graber, then what does? What are we suggesting did that? That he is inherently an evil person? That he's just a bad seed? That's kind of what we're left with if these other factors don't explain how we got here.
Well, doctor, if you're saying that it does explain the murder of Mrs. Graber, I hope you're not suggesting that it excuses it.
I'm not saying it excused it. I'm not saying it absolutely caused it. I'm saying these factors inclined the angle of the choice that Jeremy had and correspondingly reduced his moral culpability.
Fair enough. There's a lot of testimony about the pandemic and the effects on Jeremy. He went to school online, right?
So there was a little testimony about the pandemic. There was a slide or two about that. He did go to school. He was at the Immaturity school. They went online in early 2020, and he was subsequently online.
And there was a lack of supervision during his online schooling.
That's right.
And there was some tension with his father's expectations of his schooling.
Oh, there was more than simply tension. Dean was expecting that he structure himself to be able to do this. Jeremy, by age and ADHD, simply did not have that capacity. As he's not structuring himself and Dean ramps up the pressure, their relationship deteriorates. And there's more conflict and more meltdowns.
The educational aspects of the COVID pandemic were in no way unique to Jeremy, correct?
That's correct. His experience of it may be unique,
sure.
But the context itself, it wasn't just Jeremy who was sent home. All the kids were online.
All the kids were online. All the kids were isolated. There were probably tensions in the home. This is certainly not a unique circumstance to Jeremy, right?
His experience of it, I think, was more unique based on his own vulnerabilities and family structure and that kind of thing. This was a developmental disruption for all the kids involved. That was not for free. That has ended up with repercussions in their lives. So there's concern about the reverberating mental health and educational and social impacts that happened as a result of keeping kids at home during the pandemic. And so it may have been necessary from a public health standpoint, but it was not an intervention that was for free. There are casualties that have come out of that.
Kind of like with Jeremy's home life, keeping Jeremy at home during the pandemic does not explain his decision to murder his teacher.
It's a factor that contributed to the trajectory that led him there. That's why I testify about it, because it diminished and disrupted the resources that he could bring to his decision making, and in that way is part of that explanation.
Doctor, would you say that the effect of the pandemic on Jeremy's education in any way excuses his decision to kill the teacher?
Well, no, sir, none of this is an excuse. We're past that. He's pled guilty. And so we're beyond excuses. That's a guilt phase issue. Now we're talking about what resources he can bring to bear. And when you set it up as an excuse, it's as if we're back at the guilt phase. We're past that. No longer excuse. Now, based on what resources he had available to him, what's the appropriate sentence? We're not in the excuse zone anymore. Now, it isn't the disruptive effect that it had on his education that I'm concerned about. It's the disruptive effect that it had on his psychology and on his relationships. That was the damaging part of the pandemic, not that he fell behind in his schoolwork.
And Doctor, we've talked about irreparable corruption and that Jeremy is not irreparably corrupt. Would you describe irreparable corruption?
So that would be someone whose criminal and criminally violent proclivity is a function of their character and personality that has become fixed in them. From whatever cause, it's like concrete that's no longer wet and is hardened. Well, now because that's hardened, there is an enduring specific deterrence problem. You may still have mitigation in that they didn't choose to have that character. This is a character that was developed as a result of deprivations and damage, so the mitigation, the moral culpability piece is still there, but because it's now hardened, we have an enduring specific deterrence problem about letting them out. That's where this Miller defendant data is so helpful as we look at these adolescent murderers who, by their conduct in the community, demonstrate that the concrete was not hardened back here as teenagers.
So an irreparable corrupt individual would need to be warehoused as a public safety concern, correct?
Yes.
And Jeremy is not irreparably corrupt based on...
Not by my judgment.
But does that not take into account the present state of the law in Iowa? Jeremy Goodale cannot be sentenced to life without the possibility of parole, correct?
That's right.
So the state of the Iowa law as it exists today takes into account the fact that somebody who commits a homicide before they turn 18 cannot be legally irreparably corrupt.
Well, the life without parole issue is not simply about being irreparably corrupt. It's also about the limited resources that adolescents could bring to their decision making that would say that the needs of justice are not properly addressed if the mitigating effect is not recognized. Irreparably corrupt from a specific deterrent standpoint would say that this person needs to be quarantined as long as possible. Might not be life without parole, but it would be long term.
But in reviewing your report and your testimony in court here in the last couple of days, it appears that the thrust of your argument is that Jeremy should not be warehoused away, that he is not irreparably corrupt, and that he has a chance of rehabilitation at some point in the future. Correct?
That half of my testimony, yes, the other part of it talks about the resources that he brought to his decision making.
But that's completely consistent with the state of the law as it is today, right?
I don't think my testimony is contrary to the law as it exists today. It's trying to illuminate the application of that law.
Okay. Okay. Thank you, Doctor.
Thank you.
Go ahead, Mr. Cook.
Thank you, Your Honor. Dr. Cunningham, just a few follow-up questions. You were asked a question about being retained by defense counsel. If the science that you are so obviously qualified to testify about were helpful to the state, would you be willing to testify for the state?
Well, certainly. I don't base my involvement in a case on whether I'm contacted by the state or the defense, and I do the same evaluation regardless of who calls me, and then would present it in the same way. I understand why the state has not retained me in this case to do this same evaluation and present this same testimony. Because this science is not helpful to what the state is typically asserting at either capital sentencing or at youthful sentencing. And that assertion is typically one that would emphasize the volitional choice of the defendant that is made out of what we might characterize as an evil heart, that's how we got here. And so that means that he needs to be maximally punished because of that volition, and he needs to be incarcerated indefinitely because of that inherently evil heart that is, of course, an immutable condition. Now, the science of psychology, by contrast, is that the involvement in criminal violence and in murder, and particularly for youthful murderers, is not simply the wholly volitional product of a malignantly evil heart, but is instead decisions that are made out of the limited apparatus of a juvenile brain that may be particularly immature in its functional maturity based on the deprivations and adversities that have happened, often augmented by mood disorder or substance dependence, that in an environment or in a social interaction that youth doesn't have the capabilities and the ego strength to extricate himself from. And that out of that, it's not that he's not guilty, it's not that he's not held accountable, but that those vulnerabilities and the prospect for having a meaningful, contributing, constructive life in the community are such that should be taken into consideration at sentencing. So I'm like a researcher that studied the relationship between cigarette smoking and cancer and found there to be a relationship. I'll never be called by the tobacco companies. Not because I have a bias, but because that's just the nature of the science.
You were also asked questions about your hourly rate, and I think, just so the court is clear on this, Dr. Cunningham, and you did address this, your estimate when I originally contacted you was substantially less than the time that you ultimately expended in this case, correct?
That's correct. The efforts and time that I exert to a case, I base on what I regard as the requirements of the case and my own internal standard of excellence. If I get approval for that time, that's good. I like that best. If that approval is not extended beyond what was originally estimated, then that's simply something I've donated to this court.
And in this particular case, you've expressed your willingness to do that, correct?
That's correct. In my communications to you, I've described, here's my time involvement. You guys let me know what you want to do.
And I think the implication of those questions essentially is that the defense paid for a favorable opinion from you. Is that accurate?
Typically, as the money is brought up, that's when there's nothing else to really discredit me about. So if you can't do anything else, then talk about the money. And so that's kind of that's how the cross-examination may work.
And in fact, as I know we have discussed this and it's part of your CV, you've received awards and commendations from judges that you've worked in front of, is that correct?
So I've had letters of recommendations from judges that I've testified in front of that have been submitted in support of some of the national recognition that I've received.
These weren't defense attorney judges, right? These judges are neutral arbitrators of what's happening, correct?
That's correct. Who I testified in front of and found that testimony to be worthy of some additional attention.
Now, to address a couple other topics here, is it accurate to say that the underlying principles, the science, would be the same in every juvenile case, and as indicated by your statement that a lot of the slides that you've used in your presentation here over the last 2 days are duplicative of other juvenile cases that you worked on?
That's correct. The slides that address the science are duplicative, and the slides that address broad concepts are duplicative. The case-specific slides are specific and were created in response to what I observed in Jeremy Goodale's childhood and family and community experience. As
an expert, as a board-certified clinical and forensic psychologist, these are all science-based opinions that you've been able to provide with hard data to support your opinions. Is that correct? Well, so the science is the foundation for it. That tells me what to pay attention to and what meaning it has.
then I take that science and my clinical experience as I gather data and do an evaluation in a particular case. That data is then informed by the scientific methodology that's brought to bear and by the scientific research that attaches what meaning it has, that answers the so what question. So what he was depressed. What does a mood disorder have with violence in the teenage years? Okay, it's the science, it's the studies that give meaning to that. So I'm taking a clinical history about mood disorder, and then I'm looking to the science to identify what meaning and import does that have.
And because you're a forensic psychologist, you would certainly be aware that the U.S. Supreme Court decisions, particularly Miller, that is the basis for this change in direction as how we treat juvenile offenders, particularly in murder cases. The driving force there is the science, correct?
Well, that's exactly right. The Miller decision heavily cites to the Amici brief, the friend of the court brief, filed by the American Psychological Association, as well as other scientific organizations that detail these changes in brain development that I've testified about. And it's that integration of science into public policy that resulted in this kind of sentencing proceeding about how a juvenile murderer is sentenced, is out of recognition of these limitations of youth.
You had discussed Doctor, during your discussion of judgment impulsivity, you discussed, and you've discussed throughout the course of the last 2 days, how there's basically good planning and bad planning, and it could depend on, you're looking at those factors to determine if this was a impulsive judgment on that person's part. And you discussed whether or not there are weeks of planning or months of planning. I believe you said it in this case before, but as it applies to Jeremy's case, what were your observations of the planning in this case?
That it was outsourced, that it was primitive, that it extended only as far as accomplishing the murder, largely with problematic to catastrophic improvisation after that.
Would you describe this as weeks of planning?
I would describe this as minutes of planning repeated over a 2-week period.
Would it be accurate to say that no one thing led Jeremy to make the decision to get involved in this horrific crime?
Oh, yeah, that's fair. I mean, obviously the seminal event is Chaden's request. Chaden doesn't request him to assist. Jeremy has now graduated from high school. None of this happened. So that's the pivotal event that happened. None of the formative factors alone determined his agreement and subsequent participation.
And despite the state's cross-examination and your answers in response, would it still be your position that the Board of Parole, at the time they make that decision, would be in the best position to make a determination as to Jeremy's rehabilitation?
That's correct.
I have no further questions, Your Honor.
No recross, Your Honor.
Thank you, Dr. Cunningham. You can step down.
Thank you, sir.
further evidence from the defense?
No, Your Honor.
So then, counsel, I was going to have the state give their recommendation on sentence, then have defense counsel give their recommendation on sentence, then Mr. Goodale would have the opportunity to make a statement if he chose to before sentencing, and then there would be victim impact statements. Are we all on the same page there?
Your Honor, I've consulted with defense counsel previously, and the state has no resistance. I think they were wanting to have Mr. Goodale make a statement prior to the arguments of both state and defense.
That is correct, Your Honor.
Is that, are we ready to do
As
that?
long as victim impact statements are last, which is where they should be, that's will remain in that order.
That's correct, Your Honor.
Okay, so at this time, Mr. Goodale, you have the right of allocution. Do you wish to make a statement before I sentence you?
Your Honor, before he begins, I would request permission to reorient his chair so he can face the Graber family.
Go ahead. The only, just so Laura can hear him, so I don't know if we need to put a mic on him. Yeah.
I think they're going to mic me up. I want to say I'm grateful for this chance to speak my piece. I offer my sincerest apologies to the Graber family, but I know my words will never be enough. I've had time to think on what to say, and I'm sorry, truly sorry. What I've taken can never be replaced. Every day I wish I could go back and stop myself, prevent this loss and this pain that I've caused everyone. Everyone in the community and outside of it, those closest to me and those closest to the Graber family, as well as the Graber family. I didn't know how taking Miss Graber's life would affect you. I can't comprehend losing a loved one in such an awful way. I'm sorry I didn't stop this from happening in the first place. I'm understanding now that Miss Graber meant so much to so many people. She was a support to the community and those close to her. And she was a caregiver to her family, to her children, and to her own husband. I'm so sorry. To Mrs. Graber's friends and the members of her church, I'm truly sorry for what I've taken from you. I never stopped to consider the community. To everyone at Fairfield High School who felt unsafe, those who were scared, those who lost hope, I'm sorry for what I've done. I'm sorry how my actions have affected you. I owe an apology to all my friends. I'm sorry for the stigma placed on you just for having known me. Zach, Habib, Zoe, and John, I didn't care. I didn't even know what this had done to you. And I'm sorry. And Dad, I'm sorry that I let you down in so many ways. Jackie and Sophia, You've given so much to me. I'm supposed to be helping you and Dominic right now, Jackie, but I can't. Instead, I've caused so much stress, and so much loss, and so much grief. And to all of my siblings, I took your little brother. And Dad, I took your son from you. 2 years ago, I made the worst decision of my life, and I take full responsibility for what I did. And today, as a young man, I can begin to pay for that. I can never give back what I've taken. But I hope that this situation doesn't end as tragically as it began, and that someday something positive can come from this tragedy. I know that my words will never be enough, but to Miss Graber and all her family, I'm truly sorry. Thank you.
Does the state want to be heard on sentence?
Yes, Your Honor. Your Honor, it's important to keep in mind how we got here today. As Jeremy detailed in his Snapchat messages, the last thing she ever saw was Jeremy's face. She was walking in the park on November 2nd, 2021. She was coming up the hill. Jeremy was wearing a mask, shock of blonde hair coming down. He was walking towards her. She got frightened. She got scared. And he took down his mask to reassure her. And he smiled. She smiled back. And he was looking at her in the eyes when Shaden Miller walked up behind her wearing yellow gloves and a baseball bat and took her life. Jeremy was the last face that she saw. He then aided Shaden in dragging her into the woods and hit her in the head 5 times, ending her life. Jeremy acted in consort with the co-defendant in this case, and the state's recommendation is based on a lot of factors. 902.1, sub 2, sub B, sub 2, sub A details a number of factors that the court needs to keep in mind when considering the appropriate and effective judgment and sentence to pass down for this crime. Subsection A indicates the court needs to consider the impacts of this offense on each victim. Well, Your Honor, the victim is dead. The impact cannot be more grave. And on the people she's left behind, the impact will be heard by the court shortly. But it's fair to state that the death of Nohema Graber has fundamentally changed the nature and structure of this family. Sub B indicates the court needs to consider the impact of the offense on the community. This offense has had a substantial and lasting impact, as testified to by Lieutenant Kinsella. Subsection C indicates that the threat and safety of the public needs to be considered by this court. The defendant had no motive in this case. His motive was to assist in Shaden Miller. It was Shaden's motive. Jeremy was along, in his words, quote, because he didn't want to seem like a pussy, end quote. That lack of motive could cut a couple of ways, but frankly, increases the threat.
I think we might need to take a break here for a second. The defendant's got a bloody nose.
Oh, sorry.
No, you are fine. We'll let's take a break and see if we can get that taken care of. We're off the record. Do you want to go to lunch now, or do you want to keep going?
I'm fine to go to lunch. I think it's probably...
Your Honor, my argument would be substantial. We need to go to lunch first.
Okay.
how's
We have
that?
10 victim impact statements also, just keep that in mind.
So let's come back at 12:45 then? All right, we'll be in recess.
Just one foot right after the other.
All right.
Please be seated, everyone. Thank you. We are back on the record. After our lunch break, Mr. Molding, I had interrupted you, but you were beginning with your recommendation for sentence.
Yes, Your Honor. If, with the court's leave, I will continue where I left off.
Go ahead.
I was discussing the factors of Iowa Code Section 902.1 sub 2, sub B, sub 2, sub A, and the court's 20 factors that it needs to consider when sentencing Mr. Goodale. I was speaking about subsection C, the court's consideration of the threat of safety of the public, and that while defendant had no motive in this case, that frankly adds to the concerns for the threats of safety to the community. No motive means an enhanced risk of other stranger victims. Subsection D dictates that the court consider the degree of participation in the murder by the defendant. The actual act of the homicide involved the defendant distracting the victim, having her recognize him, take down his mask, and identify with him, disarm her, and make her less concerned about the facts and circumstances that were about to befall her, and then finally finishing her off once she was drug off the roadway. To say nothing about the disposing of items after the fact and the planning beforehand. Subsection D should be strongly considered by this court. Subsection E considers the nature of the offense, which was a brutal homicide. Subsection F is the defendant's remorse. Now, on the day of his arrest, it's been testified several times before that the defendant stated, quote, "I don't feel guilty, I don't feel remorseful." That is, at the time, it's conceded by the state that the defendant did make a very heartfelt, remorseful statement just now, and I believe he means it. I think that should be taken into consideration by the court as well. The defendant's acceptance of responsibility is dictated by subsection D, has been full and complete, which also needs to be considered by this court. Jeremy has taken full accountability for his role in this case. The severity of the offense, as dictated by subsection H, could not be more severe. First-degree premeditated homicide, which was heinous, brutal, and cruel. Subsection I dictates the court consider the capacity of the defendant to appreciate the criminality of his conduct. Defendant understood murder is wrong. The doctor spent more than 3 hours here testifying about the defendant's state of mind and other factors to take into consideration with regard to his upbringing and his state of life. But I believe that Dr. Cunningham also testified that a 7-year-old knows that murder is wrong. The defendant certainly appreciated the criminality of his acts. Subsection J requires the court to consider whether the ability to conform with the defendant's conduct with the requirements of law was substantially impaired. I don't believe that there's any record to indicate that that was not the case, despite the fact that the defendant was admittedly impaired by marijuana at the time of the act. The level of maturity of the defendant, dictated in section K, the defendant was rational and reasonable for a 16-year-old boy. His grades indicate that while he may have not been the first in his class, he was a very smart young man, and capable of mature thinking and rational thought. The intellectual and mental capacity of the defendant was normal. The nature and extent of any prior juvenile delinquency, the state concedes there was none. The defendant, up until this point, was a relatively law-abiding citizen. Obviously, there were juvenile indiscretions, use of controlled substances, but nothing that would, no record of juvenile delinquency, let's say. Subsection O requires the court to consider the level of compulsion and duress that gave rise to this. Any compulsion or duress would have been social only. He explained why he took part in these crimes after weeks of consideration, why he didn't stop it 2 weeks ahead of time, or the day they stalked Mrs. Graber, or the minutes leading up to it. And Jeremy indicated he didn't want to seem like a pussy in front of Mr. Miller. The chronological age of the defendant is 16 years old. Subsection R, the family and home environment that surrounded the defendant. As discussed with Dr. Cunningham, the defendant was cared for, his family loved him, he had a roof over his head, he never suffered food scarcity. His family life could have been better, but it is certainly not outside of the norm for the court's consideration. The circumstances of the murder, including the extent of the defendant's participation in the conduct, and the way familial and peer pressure may have affected the defendant was fully involved in Mrs. Graber's murder. He didn't deliver the first blow, he did deliver the last blow, and his conduct was fully engaged in this crime. Subsection T dictates that the competencies associated with youth, including not limited to the defendant's inability to deal with peace officers or the prosecution, or the defendant's incapacity to assist the defense attorney in his defending of the case. The state, police officers, and the defense attorneys, or I assume defense attorneys, have had numerous consultations with the defendant. He is fully competent and involved in the considerations that lead us to court here today. Subsection U asks about the possibility of rehabilitation. Frankly, Your Honor, the state is hopeful in this case. I think everybody agrees that the possibility of rehabilitation of Jeremy Goodale does exist. Any other information considered relevant by the sentencing court? Your Honor, Jeremy was approached by Chaden Miller 2 weeks prior to Mrs. Graber's killing. He agreed to help Chaden kill his teacher. It's not clear the level of planning and coordination that took place in the ensuing 2 weeks, but the day before her death on November 1st, he agreed to meet up with Chaden. He did stalk Mrs. Graber along with Chaden to the scene of the crime, casing it, and in fact, I think he testified that at the top of the hill, they did bump into Mrs. Graber and did say hello. He didn't call off the act at that point, and he didn't call off the act when he was sitting with Zoe Thentel at the park in the 45 minutes leading up to Chaden arriving. It's unclear what the defendant's mental state was. However, there were so many opportunities for him to change his mind and stop this, and he did not. To include when Mrs. Graber is walking towards him and he lowers his mask and he waves. He could have told her to duck. Chaden was walking up behind her with a baseball bat wearing yellow gloves. But we're not there. We're here. Following the brutal conduct of the defendant and co-defendant in the killing of Mrs. Graber, Mr. Goodale made some serious considerations. He agreed to proffer evidence against the co-defendant in this case. He agreed to testify against him, and he took full accountability, and he pled guilty to the first-degree premeditated murder of Nohema Graber, and that is worthy of some consideration. In considering all of those factors and the defendant's age and the behavior of the defendant following this crime, the state would recommend that Jeremy Goodale be sentenced to the Iowa Department of Corrections for a term of incarceration of life imprisonment, that he be withheld from consideration of parole for a period of 25 years and not considered for parole eligibility until he has served a term of 25 years incarcerated, that he be ordered to pay restitution in this matter to crime victim assistance in the amount of $16,299.06, to the Jefferson County Auditor's Office in the amount of $3,099.13, joint and several with co-defendant Mr. Miller, that he pay a pecuniary damage figure in the amount of $150,000 to the estate of Nohema Graber, again, joint and several with co-defendant. And furthermore, the state requests up to 30 days in the event that there are additional restitution figures that are forthcoming. The state does not fall on these recommendations lightly, and I believe that Mr. Goodale is a candidate for rehabilitation, but it's going to take a substantial period of time, and that there are other considerations that the court needs to take into consideration when considering this case. Thank you, Your Honor.
Thank you, Mr. Molding. Recommendation from the defense.
Thank you, Your Honor. Before I begin, Your Honor, just to address a couple of things that Mr. Molding had mentioned during the state's recommendation. First of all, the fact that Jeremy had lowered his mask just prior to his encounter with Ms. Graber, and the fact that he quote-unquote didn't want to seem like a pussy. This is information the state did not have had it not been for Jeremy's honest proffer. And again, I think by all accounts, everyone involved in this case believes that that was in fact the case, that Mr. Goodale was honest and sincere in everything that he's had to say since this unfortunate incident has happened. I have some slides that I would like to assist in my presentation.
Are you hooked up there?
Yep. Your Honor, over the last 2 days you've heard a lot about my client, Jeremy Goodale. And as he sits before you today, he is a person of only 18 years old. As Mr. Molding indicated, there are several sentencing factors pursuant to Iowa Code 9021 that the court has to take into account in making its determination here today. First is the victim impact statement. We would point out that Jeremy is remorseful for the hurt and pain that he's caused. That's reflected through his cooperation throughout the proceedings of this case since his arrest and through his allocution statement here today. We would point out that Chaden Miller pled on the eve of his trial after Jeremy's proffer and his attorney's deposition of my client, and that Jeremy admitted guilt, saving the family for what would have otherwise been a very difficult and emotional trial. Subcategory B, the impact on the community. Jeremy admittedly never stopped to think about the impact his actions would have on the community. That's come out several times in the course of this sentencing hearing. His impulsivities and his subsequent failure to consider the full gravity of his actions is evident. He's beginning now to understand the effects this has caused beyond that of the associated families. He continues to learn about the ripple effect that this has had on others and hopes that a continued understanding will help to aid in his rehabilitation. Dr. Cunningham testified that juveniles have less ability to foresee and take into account the consequences of their behavior, or ability to take the perspective of others into account, and I think that that was evidenced in this case as well. Subcategory C is the threat posed by the defendant. The best resource to know whether Jeremy will be a threat to the community upon his release, Your Honor, is the Board of Parole. Jeremy has no prior criminal history or juvenile delinquency. This wasn't Jeremy's plan. It never would have happened had it not been for Chaden Miller. Dr. Cunningham's testimony regarding juvenile brain development and recidivism, I feel, is particularly enlightening to the court and to anyone who heard Dr. Cunningham's presentation, particularly the hard facts and statistics that he used to support his position. Dr. Cunningham testified that even impulsive, reckless, and even criminal behavior is typical in adolescence. Subcategory D is the degree of participation. We would point out that this was not Jeremy's plan, that this ill-conceived plan, if you were to call that, lacked preparation, both before and after. He did not bring anything, and he exposed himself at Chaden's bequest, often taking on tasks in this ill-conceived venture that exposed himself much more greatly than Chaden, when it was Chaden's idea to move forward with this in the first place, such as pushing a wheelbarrow all the way across town in the middle of the night. Dr. Cunningham testified that Jeremy's loyalty to Chaden Miller played a role in Jeremy's decision to participate in this. Originally, he was supposed to be the lookout. He testified during his proffer that he didn't want to touch the bat, and it was only after he realized that Ms. Graber was still alive and suffering that he took the actions that he did. He took no action in the next day and a half, 2 days, to dispose of any evidence. E, the nature of the offense. While this is certainly a brutal and senseless crime, Your Honor, we would remind the court that the State v. Lyle decision directs the court to consider this a mitigating factor as it relates to juveniles, that the nature of the offense should not outweigh the remaining Lyle factors. This was a horrific crime, but it was planned by juveniles, carried out in a very childlike way. There is no real plan beyond the actual act itself. Subcategory F, the defendant's remorse. The state has attempted to equate a statement Jeremy made immediately after his arrest to mean that he feels no remorse. He was asked if he was in shock or why he wasn't freaking out, and his response was that he didn't know, he didn't feel guilty, he didn't feel remorseful. Essentially, he didn't know what he was feeling then. Dr. Cunningham's observations of this was that Jeremy's insight about himself and to his own actions were limited, and particularly limited at age 16. Jeremy saying he is not in shock is not dispositive as to whether or not he was. Even today, Jeremy cannot fully explain why he was compulsively telling people about this right after it happened. His insight is very limited. There's a good likelihood that he was in shock. There's nothing like this, anything at all, that had ever happened to him before. Jeremy was particularly functionally immature when he committed this offense, and Jeremy is still particularly functionally immature. 48 hours was still, I should say, particularly functionally immature 48 hours when he was sitting with his sister Jackie. He didn't just magically become an adult because he was charged with this crime 48 hours later. We do, and we certainly appreciate the state's kind comments in that regard. We do expect him to develop and become somebody capable of being a productive member of society, Your Honor. We expect him to develop as his brain develops, as that is the testimony that the court has received on that issue. The implications of this will be something he learns within the years to come. Jeremy has a lot of growing to do, and that's not done, Your Honor. He's 18. There are several years remaining for him to continue to grow, mature, and understand the consequences of his actions. And ultimately, with regard to his remorse, his actions do speak louder than his words. He did cooperate in this case. He accepted guilt by pleading guilty as charged to murder in the first degree, and he's receiving the highest penalty afforded under Iowa law. Subparagraph G, the defendant's acceptance of responsibility. As indicated by the state, Jeremy has taken full responsibility for his actions. He's made every step towards cooperation that he can. He proffered, agreed to provide a statement to the state without any assurances as to what benefit, if any, he would receive from that. He was completely honest and forthright. He, in addition, provided additional detail that the state had previously been unaware of. Agent Kedley testified that Jeremy was honest in his proffer, that there was no evidence to contradict what Jeremy said had happened. He pled guilty to murder in first degree. He then subsequently faced, after his proffer, being deposed by Chayden Miller's attorneys, and was subsequently listed as a witness for the state against Chayden Miller. He was prepped by the state and prepared to testify in Chayden's trial, and we believe it's likely that Chayden pled guilty in his case as a result of Jeremy's cooperation. H, the severity of the offense. The seriousness of this crime does not alter the propositions detailed in the Miller-Lyle factors. Judges cannot necessarily use the seriousness of a criminal act such as murder to conclude the juvenile falls within the minority of juveniles who will be future offenders or are not amenable to reform. That's what the State v. Lyle case tells us, Judge. The Sweet case tells us that while murder is the most serious of offenses, the presumption is still for any sentencing judge that a juvenile should be sentenced to life with the possibility of parole, even for homicide offenses. Subparagraph I, his capacity to appreciate the criminality of his conduct. And we've heard testimony on this, Judge, that a juvenile just doesn't have the same appreciation as an adult would in these circumstances. Dr. Cunningham testified to the average 16-year-old and their lack of appreciation of these dynamics. Dr. Cunningham further testified that because of his particular immaturity, Jeremy is even less mature than the normally situated 16-year-old. Dr. Cunningham not only provided his expert opinion, he also provided a lot of statistics and data to support his propositions. Propositions that essentially were uncontradicted by anything the state has had to offer in these sentencing hearings. The fact that a defendant is nearing the age of 18 doesn't undermine the teachings of Miller, and the features of youth identified simply do not disappear at the age 17 or even 18. And the State v. Sweet case tells us that. Subparagraph J, his ability to conform with the law, whether that was substantially impaired. And again, Dr. Cunningham testified regarding these dynamics. Jeremy's youth, his particularly immature status, his adolescent drug abuse, and substance abuse immediately preceding this offense all contributed to his decision-making at the time this horrific incident occurred. K, defendant's level of maturity. Again, Jeremy was 16 years old at the time of this offense. Jeremy was particularly functional immature. Jeremy's functional maturity was delayed by untreated ADHD. Dr. Cunningham drew a distinction between maturity and intelligence, and I would agree with the state. Mr. Goodale was a very intelligent young person, but he certainly lacks maturity in a lot of respects, and he has a lot of growing to do, Your Honor. Dean was concerned about Jeremy's level of maturity, and he testified about that. He felt that Jeremy was just a little bit behind as far as his development was concerned. It was the reason why he did not allow Jeremy to get a driver's license or learning permit. Subparagraph L, his intellectual and mental capacity. We would point out through filings made at the reverse waiver hearing, as well as the sentencing hearing today, Your Honor, that Jeremy Goodale teachers spoke highly of him, that his coaches spoke highly of him, that his development has been stunted by his childhood experiences, and that one day the likelihood is that Jeremy will be released from prison, and I think by all accounts he has the tools to be a successful member of society one day. Subparagraph M, his prior juvenile delinquency or criminal history. He doesn't have any. Subparagraph N, his mental health history. The court has received evidence about Jeremy's passive suicidal thoughts and self-deprecating thoughts, his continual emotional breakdowns leading to hours of crying in the bathroom in the months preceding this offense. The court has heard how he didn't have any counseling, whether it be for these emotional outbursts or for the obviously significant impact that the abandonment of his mother has caused in his life. And in addition, his mother's abandonment and the isolation he experienced afterward. He essentially went from sleeping in her own bed to her moving out of state and having no contact with him. He ultimately received little or no formal treatment or counseling regarding any of this. Subparagraph O, whether compulsion, duress, or influence were exerted in this circumstance. And again, Dr. Cunningham testified about this. He testified that peer pressure is a significantly greater component in a juvenile's thought process than it would be for an adult. That juveniles are more vulnerable to negative external influences. Dr. Cunningham testified that developmentally based desire for approval and fear of rejection results in adolescents being more susceptible to peer pressure, even without direct coercion. This is the one boy, two boy, three boy. It doesn't matter if the other person is even instigating inappropriate behavior, just the fact that adolescent males are together creates this dynamic. Far more likely than adults to commit crimes in groups and or in a context where the pressure of peers is a motivation factor. The ability to resist peer pressure is a social skill not fully developed in adolescence. Subparagraph P, the likelihood of further offenses. Dr. Cunningham showed us through statistics that based on the Miller release study and its subsequent follow-up that juvenile lifers, such as Mr. Goodale, are very unlikely, I should say, to reoffend. That juvenile lifers can be considered low-impact releasees in terms of risk posed to public safety. And separately, the court has heard about how Jeremy will continue to have the family support that he's had since the time of his arrest. We've heard from both Dean and Jackie Goodale about their constant visits and consultations with Jeremy since the time of his arrest, almost a little over 2 years ago now. He maintains contact with his other siblings as well. We've heard directly from Dean and Jackie, and they've testified that they will continue to be support system for Jeremy as he moves through this long process of rehabilitation. Jeremy should be afforded a meaningful opportunity at rehabilitation. And I think part of that, Judge, is the fact that he is a juvenile, his brain isn't fully developed. The programming necessary for Jeremy's rehabilitation should not have to wait 25 years as the state is suggesting. The last 5 factors, Your Honor, are the Lyle factors, and as the court is aware, these 5 factors are intended to serve to mitigate punishment, not aggravate it, according to the State v. Roby case. According to Roby, the district court's consideration of any potential aggravating factors set forth in 902.1 shall align with our juvenile sentencing jurisprudence so as to not overwhelm the mitigating factors associated with youth, especially the 5 factors in Lyle. So paragraph Q, under the Lyle factors, Your Honor, the chronological age, features of youth is immaturity, impetuosity, failure to appreciate risk and consequences. Your Honor, Dr. Cunningham's testimony exemplifies how this case is riddled with displays of immaturity, impetuosity, and the failure to appreciate the risk and consequences of his actions. I have several listed here, but they're not all inclusive, Your Honor. You've heard 2 days of extremely poor decision-making exercised by Mr. Goodale as it related to this offense. He outsourced the entire plan, in which ultimately his life is now hanging in the balance, to a friend. It was poorly planned. They had no plan beyond the offense, made no attempt to hide any evidence. Jeremy didn't concoct any story or alibi. Jeremy's loyalty to Chayton was misguided. He lacked emotional autonomy, and that contributed to him agreeing to go along with this instead of saying no or backing out of it. He subsequently told multiple people about his involvement, apparently without realizing that it would contribute to his apprehension. He gave no thought to how he was risking his own life. Certainly never thought about the impact that would have on Ms. Graber, her family, his own family, and the community at large. Subparagraph F, his home and family environment, and these were factors I think we took directly from Dr. Cunningham's slide. His mother's increasing failure to foster emotional autonomy with each successive child. His mother's emotional detachment from and neglect of her children when they were no longer babies. Overall broader parental neglect. His parents' excessive work hours and focus. Abdication of parental care and nurturance to Jeremy's older sister Jackie. Chronic marital dysfunction followed by separation and divorce. The mother abandoning her children for Jeff Griggs. Parental neglect, including structure, mental health care, and emotional support. Subparagraph S, the circumstances of the murder. And again, Your Honor, we would point out that peer pressure is an important consideration in juvenile cases. Dr. Cunningham discussed the association of a peer and how a peer's influence was needed for this act to be carried out. That ultimately, without each other, this offense would likely have never occurred. There was no reason for Jeremy to involve himself in the frustrations Chayton had with Mrs. Graber. He had already taken her class and passed. This certainly would have never happened had it not been for Chayton Miller. State v. Roby tells us the brutal nature of the crime does not necessarily weigh against mitigation. The aggravating circumstances of a crime that suggest an adult offender is depraved may only reveal a juvenile offender may be wildly immature and impetuous. We've heard a lot of testimony, Your Honor. The court has received a lot of evidence about Mr. Goodale's impetuosity and his immaturity. There's no aspect of this case that displays any sort of well-reasoning thought as far as the processes that Mr. Goodale exercised during the commission of this offense. Subcategory T is his youth competencies. We would point out again that Jeremy had very limited prior contact with police, that his first involvement with the criminal justice system was as a murder defendant at age 16 years old, that law enforcement spoke to Dean, and it was Dean, his father, that asserted Jeremy's right to an attorney, and he had very limited capacity as a juvenile, given his lack of understanding of process, the law, just general societal norms, to effectively assist in my and Ms. Jensen's defense of him in this case. Subparagraph U, the possibility of rehabilitation. The State v. Roby case tells us, Judge, delinquency is normally transient, and most juveniles will grow out of it by the time brain development is complete. Juveniles are more malleable to change and reform in response to available treatment, and the seriousness of the crime does not alter these propositions. Judges cannot necessarily use the seriousness of a criminal act, even such as murder, to conclude the juvenile falls within the minority of juveniles who will be future offenders and are not amenable to reform. Dr. Cunningham testified. Miller releasee data is very promising. There's an incredibly low rate of recidivism. Juvenile criminality and criminal violence does not continue into adulthood. Declining frequencies of disciplinary infractions and the assault incident at the jail are not unusual in these cases and are no longer are no long-term negative. There are no long-term negative prognoses of it. These, again, were relatively minor incidents, and Dr. Cunningham testified that he wasn't surprised by these incidents, that Jeremy is still immature, and he still makes immature decisions as his brain is still not yet developed. His finding number 14, by a number of metrics, Jeremy has a high likelihood of adjusting to the community without criminality or violence upon release as an adult. Judge, I guess to close the presentation, and I've got one additional, a few additional points that I've written down that I want to make. The presumption in this case is no minimum. That's what the case law tells us. The sentencing judge should start with the presumption of life with the possibility of parole, State versus Zerarte. The Lyle factors, quote, must not normally be used to impose a minimum sentence of incarceration without parole unless expert evidence supports the use of the factors to reach such a result. That's State v. Roby. The sentencing court is not in a position to know how long it will be before Jeremy is fully rehabilitated. The parole board will be better able to discern whether the offender is irreparably corrupt after time has passed. After opportunities for maturation and rehabilitation have been provided, and after a record of success or failure in the rehabilitative process is available. That's what the Iowa Supreme Court tells us with State v. Sweet. It would be up to him to take full advantage of the opportunities and rehabilitative services available to him. And regardless of the court's decision here today, he's still facing a life sentence. There's still a very real possibility that if Jeremy Goodale is incorrigible, that he doesn't do the things that he needs to do, he will never leave the prison system. Your Honor, I would assert we should trust the parole board to cautiously review Jeremy's progress and make a determination, as they are in the best position to make that determination as to when Jeremy is capable of being reintroduced into society. Many Miller resentencings are still in prison despite having been granted the chance of parole. We cover this a bit in our sentencing memorandum, Judge. Just because the court sets no minimum is certainly no guarantee that Mr. Goodale is not going to serve many, many years before his eligibility for parole. Again, that should be a determination made by the Board of Parole. The most accurate determination of the pace of Jeremy's rehabilitation cannot be made today. We would be forecasting into the future as to who he is. At that point, it won't be in anticipation into the future. The parole board will have its track record, and the contemporaneous data from Miller releasees will be, as Dr. Cunningham testified to, up to date at the time that the Board of Parole makes that determination. Your Honor, yesterday Dr. Mark Cunningham spoke about terms of art, using his doctorate of philosophy as an example. I would assert to the court, Your Honor, that 18-year-old adult is a term of art. An 18-year-old is not an adult, at least not by any scientific measure. The concept of a person becoming an adult at age 18 is completely arbitrary and was originally based on our government's desire to reconcile the fact that we were drafting 18-year-old boys to fight and die in war, whose society didn't otherwise recognize as adults. That's why the voting age was reduced from age 21 to age 18. If you're old enough to die fighting for your country, you should be old enough to vote, has been the rationale. 18-year-olds can now own their own property outright. They can vote in elections. They can serve on a jury. They can get married without their parents' permission. They can enter into binding contracts. And it's all completely arbitrary. There is no scientific data available back then to demonstrate and to justify treating an 18-year-old as an adult. And now that we do have scientific data available, that data does not support treating an 18-year-old as an adult. Just because it's the way that it is and has been doesn't mean that's the way that it should be, Your Honor. And our courts have finally, in recent years, began to recognize this through the litany of case law that has been cited to the court over these last few days. Our laws are finally starting to catch up with the science. but we still have a long way to go. That's why we've seen this slow but gradual progression from a time when it was constitutionally permissible to execute a youthful offender to today when a youthful offender must be afforded a reasonable opportunity at rehabilitation. Your Honor, Dr. Cunningham testified that a person's brain doesn't instantly mature overnight upon becoming 18. Brain development is on a continuum, and Jeremy Goodale, age 18, who committed this act at age 16, still has a lot of growing up to do. Dr. Cunningham testified that Jeremy was particularly functionally immature as a 16-year-old at the time of the offense, and that he continues to be a particularly functionally immature 18-year-old today as he faces sentencing. This isn't pseudoscience. I believe anyone who has listened to Dr. Cunningham's presentation here over the last 2 days now has a much greater understanding of the hard science and statistical data that support his findings. Dr. Cunningham's testimony was enlightening, it was exceptional, and it was the only expert testimony received by this court in consideration of the sentencing. The state recommends a 25-year sentence without any basis as to why a 25-year minimum sentence is appropriate, Your Honor. As a final point, I would ask the court before it makes its decision whether or not a mandatory minimum sentence is appropriate to take into account the fact that Jeremy Goodale has agreed to and will be receiving the heaviest sentence available in our state, life in prison. We are simply asking the court to defer to the Board of Parole and allow them to determine at what point in time, if at all, Jeremy Goodale will be able to re-enter society as the Board of Parole, as the court has received a lot of evidence on, is in the best position to make that determination. Your Honor, based on all of that, we're asking, again, for the court to recognize that Jeremy Goodale is receiving the maximum punishment as provided by law, life in prison. All we are asking for is the court not to make the premature decision now as to when it will be appropriate for him to be released. The Board of Parole is in that position. If Mr. Goodale is not adequately rehabilitated, as again our sentencing memorandum indicates, the Board of Parole will make the right decision. There's been a lot of legislation and consideration that places that responsibility on the Board of Parole, and I believe that in these Miller type of cases, it's where the Board of Parole would be most important, Your Honor. This is not a situation where we're looking back 20 years on a resentencing. We don't have the benefit of knowing how well Jeremy Goodale will perform in the prison system, how well his rehabilitation will go. The Board of Parole will be the best judge of that at a later time. We would ask that the court defer and allow them to do their job. Thank you, Your Honor.
Counsel, are we to the point we're ready for victim impact statements?
We are, Judge. We have 10 victim impact statements for the court to hear. I know we've started at 12:45. I guess my recommendation is that we get through a portion of those, maybe take a break, and then finish up if that's okay.
Yes.
Okay. Are we ready?
Yes.
Okay, I've got it. And one other thing to make the court aware of, Sarah Harms in my office will be reading 6 of the 10 impact statements. The first 2 will be ones that she will do. The first one is Marilyn Foost, who is the sister-in-law of Nohema Graber.
Whenever you're ready. Thank you.
The first statement I'll read is on behalf of Marilyn Foost, who is the sister-in-law of Nohema Graber. I do believe every person my sister-in-law Nohema Graber ever met became her friend, if he or she wasn't already. The only exceptions being the 2 who stole her from the thousands who loved her. She had a way of lighting up the room when she entered. That was because she genuinely cared about every person. People called Nohema an angel when they spoke of her. She had more than 50 godchildren, maybe 56, but she didn't broadcast that fact. Instead, she chose to live her love for them and anyone in need without thought of self. She never spoke of her good deeds, but lived the gospel every day with her big, joyful, loving heart. She was a private person in that way, not at all self-seeking, but her personality truly did make everyone feel lighter. When Nohema first joined the Graber family, English was tricky. It was hard to understand her speech unless one listened very carefully and patiently. It was difficult to hold a meaningful conversation in those early years, yet she did not give up. Nohema mastered the English language to the degree of becoming a fully competent and indeed exceptional teacher. Her favorite classes surely were with the Spanish students, whom she amused and entranced with tales of her beloved Mexico, all the while teaching them to speak an important language and broaden their understanding of the world's potential for them, if only they would be diligent. Nohema loved people. She prayed earnestly for them. She treasured her faith and never gave up her love for God, but instead pressed into Him when troubles came. She helped so many, so often, and so well. She knew how to love. Nohema's husband, my brother Paul, missed her so deeply. I am convinced this hastened his very recent death. We all miss her cheerful voice, her deep, throaty belly laugh when something was funny, the way she pursed her lips into an O when she was thinking around the word that was just right. She is a merciful, forgiving person who did not harbor ill will when wronged, but she did stand up for truth. She tried so hard to help people succeed, whether in their walk with God or in this life. She was an absolute blessing, an angel for sure. And the next statement I'm going to read is by Norbert Fust, who is the brother-in-law of Nohema Graber. Nohema Graber was a very special person that I have had the privilege to know in my lifetime. She was a caring, selfless individual who wanted the best for those who were struggling and needed care. St. Francis said one time, "Preach the gospel at all times, and if necessary, use words." Nohema Graber was the best example of this by her love for her fellow man. After her death, we heard so many stories of her selfless giving with the care of the less fortunate. This was especially true in her Hispanic community, who needed help and direction in living in Iowa. Nohema and her beloved church was that lighthouse of hope for those who were less privileged and needed a direction and help to succeed. Nohema's faith was strong, and this motivated her to care for others. What especially was impressive was her ability to teach others with passion. I have been associated with education for almost 30 years. Many teachers have been great educators, but not many educators have a passion for the students themselves. Nohema taught with excellence and with a caring attitude for the student themselves, becoming a person who they could receive advice from. She knew that life in this world was not easy, and you need to work hard and diligently if you want to succeed. The death of Nohema has had a profound impact on her immediate family, and we believe that this contributed to the untimely death of her husband, Paul. But now we have a situation that 3 children who may someday be married or possibly have children without the ability of having these spouses or children know their parents. Plus, they will have to take care of one of their siblings who has some special needs. I am confident you have heard what a special individual Nohema Graber was. The ability she had to live a life that God was proud of, and her selfless acts that is very hard to replace, especially for what she did for the Hispanic community in her area. It is a complete travesty to have two young people deliberately take the life of Nohema Graber away from so many.
Judge, the next impact statement that we have is Tom Graber, who is a brother-in-law.
Your Honor, this case has had enormous impact on Nohema's family, on Fairfield High School, and the Fairfield community at large. Not only was Nohema robbed of 30-some years of the best years of her life, her murder deprived Paul of the love of his life and certainly hastened his own premature death. It also had major impacts on the lives of their three children, Christian, Jared, and Nohema Marie. In the spring of 2021, Paul had just endured 5 years of dialysis, a side effect of his severe diabetes, and received a kidney transplant. Things were at last looking up for the family. Untethered from the dialysis machine, he was looking forward to resuming travel with Nohema and their son Jared, visiting eldest son Christian, who then lived in Spain, daughter Nohema, who was also working in Europe, and family and friends in Mexico. Instead, Jeremy Goodale and Willard Miller ruthlessly murdered Nohema a few months later. Paul was deeply and understandably depressed by the murder of Nohema, and his life ended in late June from the ravages of a metastatic cancer that would have been caught sooner and treated far sooner had Nohema been there. I am certain, from knowing Nohema for more than 35 years, that she would have cajoled Paul into seeking treatment and seeing the doctor and have it diagnosed as soon as the new pains and skin lesions began to he began to notice them last year. Instead, depressed as he was over her murder, he delayed seeking treatment until this past March. As he told me March 31st, as we sat together for several hours at University of Iowa hospitals, waiting for his room, he'd had several vivid dreams recently in which he saw Nohema, who came to him, gave him signs he interpreted as telling him that his time was coming, that it was drawing near, but that it was not yet his time to go to her. She was on his mind a great deal, and he spoke of her often. That time came on June 29th. Jeremy Goodale and Willard Miller's murder played a very material role in Paul's premature death. The murder has also caused great changes in the lives of Paul and Nohema's children, son Christian and daughter Nohema Marie, self-supporting adults. Both interrupted their lives to come home and help Paul in his illness. Christian this year has already taken more than 20 weeks unpaid leave from his job as an international medical courier in order to help his dad, and after Paul's death, to facilitate care for his younger brother Jared, for whom Christian has now been appointed guardian. That had not been the plan. No, Mother Nohema was the rock of the family. She was the primary caregiver for Jared. She was in very good health, had a long life ahead of her. Indeed, in this case, the autopsy comments on the strength of her heart and how her condition was much younger than her chronological age. She had a long life ahead of her. Nohema and Jared were particularly close. and loved each other's company, going to church together every week and visiting family and friends in Mexico most summers, and occasionally to Europe, using funds Nohema frugally saved from her salary as a school teacher. Jeremy Goodale and Willard Miller put an end to that too. Nohema was a truly remarkable woman. After graduating high school in Jalapa, Veracruz, Mexico, where she and Paul met when he was an exchange student, Nohema became a flight attendant for Mexicana Airlines, and on the side put herself through flight school, becoming one of the very first women to be licensed to fly passenger jets in Mexico. While unable to get a pilot's job in Mexico at that time, the mid-1970s, the flight crews, knowing of her qualifications, would sometimes let her fly a while. Paul was on some of those flights, and he's described to me how she might disappear during a flight for a long period of time, and then finally come back bubbly and excited. She'd been flying the plane. When Paul became disabled due to the extensive nerve damage to his feet and legs from severe diabetes, Nohema once again showed her strength and determination, stepping up and obtaining a bachelor's degree from Iowa Wesleyan and a teaching certificate in her 50s, becoming the family's primary breadwinner. Her murder thus deprived the family of its primary means of support. Nohema taught for a number of years at Ottumwa and was in her 10th year of teaching at Fairfield High School when struck down. There she's remembered by her many hundreds of students and their families, who have embedded a nearly 5-foot granite monument to her into the wall of the high school in a commanding position where the main hallway intersects the end hallway near her classroom. This is the photograph. Your Honor, if I may. Students and staff also established and funded scholarships in Nohema's name, held candlelight vigils in her memory, packed the high school auditorium at her evening prayer and vigil service, and created beautiful works of art in her memory. They also left flowers in a reserved auditorium seat at student concerts and performances in honor and memory of her and the encouragement and support she provided to so many outside the classroom. Area high schools also honored her, sending gifts and condolences to FHS, wearing orange and black team uniforms at their own games in support of the grieving students and staff at rival FHS. Memorials were also placed at the public library and elsewhere in town, and permanent memorials at Chautauqua Park as well as the high school. Governor Kim Reynolds also honored Nohema, ordering all flags on state property to be flown at half-staff from dawn until sunset in her honor. Such honors are not typically extended to ordinary people. Nohema led an extraordinary life of service. In addition to her nurturing roles at home and at school, she was very active in the Catholic community. She attended Mass daily, recited the Rosary every Friday evening with a group of women, a number of whom are here, and became a liaison between the church and the growing Hispanic community of Fairfield. Nohema helped many find or come back to the church, and when the son of Elizabeth Goitian was diagnosed with a brain tumor 14 years ago, Nohema prayed with her every day. Ms. Goitia's son beat the doctor's expectations and ultimately beat the tumor. He was there in attendance at her prayer and vigil service at the high school in November 2 years ago. Nohema encouraged others to return to college and finish their educations, helped them find scholarships, and pointed out that she herself had gotten her degree in her 50s. Jeremy Goodale and Willard Miller put an end to all that religious and community service as well. That is a brief sketch of who you helped murder and some of the havoc that murder has caused. You now say that you're remorseful. Your words sounded remorseful. Your demeanor looked remorseful. But I must say that your actions, to me, undercut that. You're now an adult. You're over the age of 18. And yet you have your counsel who represent you. You're in control. You're the decision maker, arguing on your behalf to escape punishment for this horrific crime. That doesn't sound like remorse to me. One of the most shocking aspects of your role in this murder is the casualness with which you agreed to take a life. According to your own testimony, after you got up from the cafeteria table one day in mid-October, went to bust your tray, Miller, standing next to you, leaned in and whispered, "Would you help me kill Mrs. Graber?" Your response, quote, "I paused for a moment and then looked at him. And then I said, 'Sure.'" Over the course of the next 2 weeks, you two met and communicated multiple times per week. You learned his motive, that this was simply over a failing grade, that he was concerned that it might preclude him from buffing up his resume by studying abroad. Murdering a teacher to avoid an F, that was apparently enough for you to go along with the crime. The two of you decided to do it at Chautauqua Park, to use a baseball bat as the murder weapon, surveilled Nohema on her daily life, daily walks there, met there in advance at the agreed upon time to carry it out. Although you say Willard Miller was your best friend, not once during those 2 weeks did you try to talk him out of this horrendously bad idea. Even on the day of the murder, when you met up with him at the park on the access trail and saw the murder implements laid out, you did nothing. You didn't try to talk him out of it. You didn't try to stop it. You could have pulled out your phone and dialed 911. Easy as that. Instead, you volunteered to serve as lookout. Let Miller know when the coast was clear, and then distract Nohema so that he could more easily sneak up behind and murder her. You had it in your power to stop this murder. Could have simply refused to proceed, could have simply walked away. Even your expert yesterday said that Miller couldn't have done this on his own. Paul talked to me at the very beginning, before we knew many of the facts of this case. He was certain there had to be at least 2 persons involved. Nohema was a fighter, and she had such intense parental urges to take care of Jared. There's no single person could have overpowered her. You also could have warned her off. You bumped into her at the beginning of her walk. You could have said something then. Suggest she walk a different day. Make up anything. Divert her. Or you could have simply proceeded. You could have just walked away. None of this would have happened. Instead, as she was approaching the ambush site, rather than shouting a warning, you did the opposite. In your own words, you said, she saw me when I was standing on the trail and walking toward her, and I had a face mask up, and I pulled it down. And I guess she was just looking at me while he, Miller, walked up behind her. Special Agent Kelly, quote, "I would assume for her being out there by herself to see an individual with a mask in front, that would have been startling. Did she stop?" Jeremy Goodale, quote, "No. And that's why I pulled the mask down, was I didn't want to startle her." You lulled her into lowering her guard and facilitating Miller to sneak up behind and strike her. Then after he struck, you said, "Well, make sure you got her. make sure she's dead. You urged him to strike her more. You then dragged her body off the main trail and, concerned that she was still alive, struck 5 more blows. Blows so savage, so forceful, that Miller, out on the main trail, heard the noise. Came running up and said, what was that noise? According to your own testimony, Nohema died as a result of those blows. You then helped hide the van, hide or destroy other evidence, and returned later that night to better hide her body. No sign of second thoughts or remorse in any of that. The next night, you bragged to friends in Snapchats and online gaming communications that Miller struck the first blows and that, quote, then I finished her off. No remorse there. At the Jefferson County Justice Center on November 4th, the second morning after the crime, you were caught on tape telling your sister, I don't feel any remorse, don't feel any guilt. Not until more than a year after the murder did you come forward and offer to plead guilty. In connection with that, you did admit much of your role, but the essential facts were already known to authorities. Courtesy of the thorough investigation by the Fairfield Police Department and other high school students who came forward immediately when Nohema was reported missing and told the police what they knew. Instead, you sent bragging Snapchats. It's not clear to me that you told the full truth in that proffer interview either. For example, Nohema's body was found almost entirely nude, clad only in a bra, with her jeans down at her ankles. Your explanation? Her clothes just came off as we were dragging her. I find that hard to believe. The 5 vicious blows you struck, so loud that Miller heard them out on the main trail, you characterized as a mercy killing. Mercy or extreme animus? It's not clear. Even on minor precursor details, you minimized your role. For example, when Agent Kedley questioned you about the egging of Nohema's home and the breaking of a window, homecoming weekend, you claimed to know nothing about it, not to have been at the house. But Nohema saw you. You, with the big shock of blonde hair you had at the time, were caught in the headlights of one of the pickup trucks. She gasped. She was shocked. She gasped to Paul, "There's Jeremy." She was absolutely astonished. Your Honor, Paul and I talked back in January and February, and when we first heard there might be a plea. We spoke again in March and April leading up to the plea hearing. We both felt that the absolute minimum should be 25 years. We were accepting of the plea agreement. We both thought 30 would more appropriately fit the crime. Something closer to her likely lifespan. Given the utter cold-blooded depravity of the crime, the casual indifference to committing murder of a teacher, and your essential role, then the crime could not have been concluded without you. And you could have easily prevented it. The wide ramifications of this crime across the community, not just to our family, we believe that 30 years would be proper before becoming eligible for parole. Were this to have occurred this November instead of 2 years ago, there'd be no question what your sentence would be. It would have been life in prison without any possibility of parole. So You're already receiving, there's already substantial consideration being given by the law to your youth. To sit there and allow your counsel to argue for 0 mandatory time is disgusting. Thank you.
Judge, the next victim impact statement is Barbara Graber, that Sarah will read her victim impact statement on her behalf. She is a sister-in-law to Nohema.
This statement is on behalf of Barbara Graber, who is Nohema's sister-in-law. Dear Judge Showers, Nohema was my sister-in-law, married to my husband's brother Paul. We had a very special friendship, and I cannot adequately express in words how wonderful she was. Nohema was a warm, selfless, fearless woman who dedicated herself to her community. She was brimming with love and energy that she shared with all those around her. Her adoring family, her students, members of her church, and her town's Latino community. I loved her, and I miss her. I have always admired Nohema for how much she accomplished for herself and for her family. She began her career in Mexico City as a flight attendant, and then trained to be a pilot for Mexicana Airlines. Shortly after her marriage to my brother-in-law, she made the decision to move to Fairfield, Iowa, and devote herself to raising her 3 children. She loved being a mother. It was her true vocation. But when her family needed her to support her disabled husband and special needs child, she enrolled in college, retrained, and began a career as a Spanish teacher. Nohema found joy in all her jobs, and she excelled at each of them. The impact of her death is immeasurable. 8 months prior to her murder, Paul received a new kidney. At last, after years of dialysis, things were looking up for the Graber family. Their prayers had been answered, and Nohema and Paul were making plans to truly enjoy their golden years. Her death put an end to so much promise for the future. Not only did Paul lose his life's companion in a horrific way, but Mr. Goodale's actions had a direct impact on Paul's own health. The all-consuming grief of losing the love of his life led him to ignore symptoms of an illness that, caught early, could have been easily treated. Instead, Paul passed away on June 29th of this year. Nohema's youngest son, Jared, has significant special and medical needs. Nohema worked tirelessly to meet his needs and enrich his life. She brought the world to him. She took him to Mass regularly and on international trips to visit family. Mr. Goodale's actions caused his son to lose a caregiver. The question of what will happen to Jared without his mother to provide for and care for keeps me up at night. I constantly worry about what's next for him and her other children. It's so cruel that they will not have their mother when they get married, have their own children, or experience any other moments when they would want her advice and counsel. I share this so the court understands the full extent of harm Mr. Goodale's actions caused. He did not extinguish just one soul in independent life, a horrific act on its own, if that were the case, but instead caused a disabled man to lose his partner, a special needs son to lose his caregiver, and an entire family to lose its primary breadwinner and mother. It's been 2 years since Nohema's murder. It feels like Mr. Goodale has been a part of our lives for 10. I am so ready to clear my head of thoughts of Jeremy Goodale and his co-defendant, Willard Miller. It haunts me that the last words Nohema heard and the last face she saw on this earth were those of Mr. Goodale. They should have been words and faces of her loving family as a priest was offering her last rites. Regarding Mr. Goodale, I appreciate that he agreed to plead guilty. I have read the transcripts of Mr. Goodale's proffer and deposition, and they were helpful for me in understanding some elements of the crime. I'm conflicted on whether I can believe all that he said when I don't believe some of what he said. As just one example, he states that Nohema's clothes came off when she was dragged through the woods. I did not believe that. She was practically nude when her body was found, and her clothes looked to be in a localized area high up in trees and shrubs. It troubles me that he can confess to taking her life, but not her dignity. It was painful to read that he told his father his reason for striking Nohema was that he felt like it was a mercy killing. That I killed Mrs. Graber as like a mercy killing. Essentially, that is what I told him. I don't think he showed any mercy. I believe Mr. Goodale would not be here but for Mr. Miller. However, he wouldn't be here if Mr. Goodale hadn't agreed to take part in this ruthless crime. It's my belief that Mr. Miller did not have the nerve to do this murder alone. He needed an accomplice, and Mr. Goodale agreed to be that accomplice. Even with my doubts about some of what Mr. Goodale had to say, I do believe him to be truthful on the most important elements of the crime. Mr. Miller had the motive, brought the weapon, and struck the first blows. I wish Mr. Goodale no harm as he pays his debt to society. Nohema could conceivably have lived another 25 years. I would like to see Mr. Goodale live those years behind bars, according to the plea agreement between the prosecutor and defense. A life sentence with a minimum of 25 years served before the possibility of parole. I hope Mr. Goodale can find ways to improve himself while incarcerated by furthering his education, learning a trade, finding faith, and at a minimum, asking for and receiving God's forgiveness. I want to acknowledge my husband, Tom Graber, for all he has done these past 2 years. He has always been very close to his older brother, Paul, and has been a loving and supportive uncle to Christian, Jared, and Nohema Marie. Tom was on the first flight he could get from our home in Dallas, Texas, when he learned Nohema was missing. Stayed through her funeral and attended all the major hearings on this case. He spent countless hours coordinating communication between the county attorney's office and the extended family. He flew up to be with his brother Paul as he was dying and stayed through to Mr. Miller's sentencing hearing. Since that time, he has helped Christian become legal guardian and set up a trust for his younger brother's care. Tom spent a great amount of time and lost a great deal of sleep over the handling of his disabled nephew's affairs. All of this while working a demanding and stressful job in Dallas and being there for me and our own children and granddaughters. He made it look easy. I know it was not. And finally, my thanks and gratitude to the following: Jefferson County Attorney Chauncey Molding and his staff, the Fairfield Police Department and Jefferson County law enforcement officers, Iowa Assistant Attorney General Scott Brown and his staff, the Iowa Division of Criminal Investigation, the state coroner and staff, victims advocates, personnel, Judge Sean Showers and his court officers, Father Nick and staff, to parishioners of St. Mary's Catholic Church, and Nohema's many friends in Fairfield. You guided us through this most difficult time with gentle hands. Thank you.
The next impact statement before break, Judge, is Jeremy Graber, who is the brother-in-law.
As you've already heard multiple times, Nohema was a fantastic person. We know now, we've known from the get-go, we know where she is. She went straight to heaven. Thank goodness. She would do anything for people. She was full of nothing but love. Cared for others. She cared for strangers. Didn't matter. She loved everybody. And for this to happen, it is just insane. Jeremy, you took part in the murder of my sister-in-law. Largely due to probably lack of common sense and lack of conscience. As they said, that develops at a 7-year-old age. You should know you should know not to kill people. It would have been that simple that day or any time in between. There's a strong chance that had you declined Willard Miller's invite to help him, that it never would have happened. And that's the sad part. And the ease at which you had with saying, sure, I'll do it. Nohema's death greatly contributed to the health and decline of Paul Graber, her husband, and my brother. I want you to think about this. My brother Tom said you could have done a 3-letter call to 911. I'd make it simpler yet. You could have done 2 letters, N-O, no. At any time between that 2-week period, you could have said no, and there's an extremely good chance even the Dr. Cunningham said it probably would not have happened. It was an evil deed, and in the death of Nohema, it took a direct impact on the death of my brother Paul, which greatly impacted his 3 children and the community and our family. Not to mention the effect on your life to this point in a very negative way. You have a heavy burden to carry for this horrific action. I do want you to know, I pray that you will continue your journey to faith to find God, and I pray that you will. I pray for your safety and salvation. I hope you do find God, and you find a good church, a God-fearing, Bible-preaching church somewhere, whether it's prison or after that can help you stay on the correct path in life. And lastly, to end, a couple of things. I don't blame your family. We have no ill feelings against your family, unlike an expert witness. I don't have any hard feelings against your sisters. It was up to you. We all are responsible for our actions. We have to be. And I do appreciate your apology today. And time will only tell how sincere it was, but it did seem sincere. But I do, contrary to Dr. Cunningham, want to say that being a teenager and still being a virgin in the godly view is a very honorable position to be in, whether it was meant to be or by accident. So, well done. We wish you well, but Judge, I also recommend minimum 25-year sentence with the life sentence. Minimum of 25 before parole. It's only fair with the years that were cut off in Nohema's life. Thank you.
You said you wanted to take a break.
I think so. We have 5 left. I'm not sure how long it'll take, quite honestly, but I think that
We'll take a 15-minute break. Be in recess. Okay, we are back on the record. Mr. Brown, you can call, or we can have our next impact statement.
Next impact statement is Deanne Graber, who's the sister-in-law, also read by supporters.
This statement is by Deanne Graber, who was Nohema Graber's sister-in-law. My name is Deanne Graber, and Nohema Graber was my sister-in-law, and I am married to her husband's brother, Jim. There are not adequate words to describe fully what this horrific, senseless murder of my sweet sister-in-law has meant, not only to the large Graber family who loved her and adored her for countless reasons, but also Nohema's large family in Mexico who cherished their oldest sister and aunt as well, along with extended family from both sides. I am so thankful that neither set of parents were still alive and had to be told of the despicable evil that descended on their precious daughter on November 2nd, 2021. Hundreds of family members miss her every day, along with thousands of friends. I will never be able to forget the evening Paul called my husband to tell him Nohema was missing. We were at our daughter's for dinner, and I was playing a game with my 8- and 6-year-old grandsons when my husband's cell phone rang. I could tell by the sound of his voice that it was serious. It was a concerning call and was not going to be a good news. When he hung up, he said, "Nohema's missing," in the most shocked voice. My 6-year-old grandson Wesley said, "Gigi, what does missing mean?" This would be the beginning of what would become a devastating loss of innocence for my 2 grandsons, Ethan 8 and Wesley 6. Because not only did I have to explain in detail what it meant for their sweet great aunt to go missing and pray for her safe return, the very next day we would sadly have to introduce the vile word murder to their vocabulary at such a tender age. Definitely one of the hardest emotional conversations of our lives that literally made me sick to my stomach. They had so many questions that we could not begin to answer. No one could at that point, and still can't, and we know it will continue. All we could do was grieve and pray like never before. On June 21st of 2023, I was at a park in Bettendorf near my grandson's home. It's one of my favorite things to do with them on our midweek visit. That Wednesday on our walk back to the car, Wesley, now 8, saw a bronze marker on a tree near a couple of benches at an overlook of the creek. He stopped to read it and asked why a lady's name was on it. I explained that she had died and her family had planted a tree in the park in her memory because it had been a favorite place of her when she was alive. He wanted to know how she died. I told him, well, the plaque doesn't say, but maybe it was a car accident or illness. He immediately said, "I know." I asked, "How?" He made his hand in the shape of a gun and hit himself in the head with it and said, "Murder." I stopped in stunned silence and knew exactly why he said this. Nearly 20 months after the senseless murder of his great aunt in her favorite park for a walk, and it broke my heart all over again. I gave him a big hug and I told him, "Let's sure hope that isn't what happened to her." Nohema was hands down one of the sweetest souls I knew. She was my favorite family walking buddy, and she would crack me up when she'd ask, "Do you want to go on a walk on the dirty road?" instead of just the dirt road near the farm. We'd catch each other up on family and friends we were praying for, and once she told me a story I shared with her gave her chicken bumps instead of goosebumps. She and my daughter loved to knit and crochet together, and she was always excited about any new craft projects happening in the family, and her blonde was a Graber family favorite. Nohema was a constant ray of sunshine in all of our lives, and we are all better people for having known and being loved by her. I loved her rock-solid faith and so admired the strength and peace it provided for her in the difficulties of life. She was a mighty prayer warrior, as well as always looking on the bright side of every situation. She made everyone feel like you were part of her family, and she had an encouraging, positive word no matter what was going on. I am sure she was the same incredible pillar of light in all areas of her life, be it family, church, work, or community. The loss we have all suffered has been of major significance because of this horrific, evil crime that snuffed out a cherished daughter of the Most High God. I pray her soul fled straight to heaven the very moment her precious head was struck. I had never personally known anyone to be murdered in my 60 years of life, and I will never be able to understand or wrap my head around the murder being a legitimate option for bad grades, or how you could ever talk a peer into doing something so heinous to your teacher. It's left me feeling much more cautious and leery going to and from work, running errands, and even taking my grandsons on outings to the parks. What breaks my heart most of all, though, is that you have absolutely robbed her own 3 children of their precious mother. She will not be there for any more of their life events, especially their weddings and future grandchildren she would have absolutely cherished. Yet these same children choose to forgive you immediately, while most of us were still in the stage of shock. Again, this is an enormous testament of who Nohema was and the incredible job she did raising her children. Forgiven people, Christians, are forgiving people, and her children have been the epitome of this. By the grace of God, we will follow their lead because we do not want you to take any more from us than you already have. We will live to honor her memory and love her children in her absence. The one thing that carries me through the toughest days is the assurance of heaven and knowing we will be reunited with her one day in glory, where there will be no more tears, pain, or suffering for anyone who repents and believes in Jesus Christ as Savior and Lord. This would have been a daily heart desire of Nohema, that everyone she knew would come to this life-changing, life-giving relationship with a personal Savior, including all of her students. To me, a fair sentence would be 50 years, which would have you released about the same age Nohema was when you horrifically took her life. You easily robbed her of several decades she would have enthusiastically relished with her husband and children and future grandchildren. Memories none of them will have the opportunity to make now. The enormity of this loss cannot be measured by her family, friends, and community members, but we will all strive to live our lives in ways that will honor Nohema's devotion and service to all, and for such a beautiful example of a life well lived.
Judge, the next impact statement is Bill Graber, who is a brother.
I will remember Nohema Graber as a kind and wonderful soul. She was my sister-in-law, a community leader, and my friend. I knew Nohema for almost 40 years. In 1984, my parents, Brother John, and I took a train trip from Iowa to Mexico City. She and my brother Paul met us at the train station and showed us the wonders of central Mexico. She was a bright and beautiful flight attendant for Mexicana Airlines, which allowed her to travel throughout Latin America, the US, Canada, Europe, and
Morocco, Israel, and India. She took the initiative to enroll in pilot flight training school, where she graduated near the top of her class at a time when Mexican Airlines, unofficially, would only hire male pilots. Still, Nohema remained ever cheerful, adept at getting along with people, and making them feel comfortable in many different situations. She and Paul married 2 years later, eventually coming to live in Jefferson County, Iowa, where the Graber family has lived for 7 generations. When the children were nearly grown, she again took the initiative, this time to get her teaching degree. First, she worked in Ottumwa, then Fairfield. What amazed me was how her former students absolutely flocked to her at community pancake breakfasts on the square, or came up to her individually at chance meetings at the grocery store. They clearly appreciated what she had taught them. Not just the language, but Spanish culture and life lessons, such as how to treat all people with kindness, dignity, and respect. Nohema Graber loved family and travel. She made the most of her summers by linking the two, by taking family vacations to Mexico, South America, and Europe. Her 3 children are well-traveled, and 2 chose international careers. Nohema and I often discussed world events, travel tips, and travel plans, which became a special bond. She and I had started plans to link up in Scotland with our respective families in the summer of 2022. She was my sister-in-law and my friend. Sometimes I chuckle at now when Nohema from the tropics, at her first autumn in Iowa, she would wear a parka when the temperatures dipped to 58 degrees. Yet later she would venture on 2-mile treks in the dead of winter, when we native Iowans could only leave the farmhouse to pile more wood on the fire. She was very adaptable and valued exercise and good health. Nohema liked to share Mexican cooking and culture with us. This ranged from chicken mole, which we didn't quite take to her lightly sweetened flan, a type of custard that we always begged her to make at every family gathering. Nohema was also the glue that kept her family together, particularly in helping Paul keep up his medical regimen. If she had been alive, she would force Paul to treat his cancer while he still had a chance. We believe that her early death cut short Paul's life. Nohema was important to us. We appreciate her many contributions to the Graber clan. The side of Nohema that we didn't fully understand before her death was her leadership role in the Catholic and Hispanic communities in Southeast Iowa. We knew that Nohema had been the church secretary at St. Mary's before she became a teacher. Every day, after teaching Spanish at Fairfield High School, she drove to Chautauqua Park to walk her rounds, regardless of the weather. Then she attended Mass at St. Mary's before coming home. At St. Mary's, Nohema attended Mass 7 days a week, counseled parishioners, and truly lived her life according to the scriptures. In Hispanic culture, La Maestra, or teacher, is a highly revered position, even more so than in Anglo culture, which makes her death all the sadder. Nohema was a lovely, kind, intelligent, helpful, hardworking person who returned to FHS to teach Spanish at age 66, even though she could have retired in peace. She wanted to make a difference. She was so healthy, mentally, physically, and spiritually, that I had expected her to live well into her 90s or beyond. Her brutal and senseless death, instigated by Willard Miller and aided by Jeremy Goodale, profoundly impacted our family, the community, and teachers across the country. Nohema deserved better.
Judge, the next 2 impact statements are John Graber, who's a brother-in-law, and Socorro, who is a sister of Nohema. Both will be read by Sarah Rose.
This statement is by John Graber, who was Nohema's brother-in-law. Dear Judge Showers, Nohema's absence has created a very adverse effect for not only our family, but the community as well. She was a loving wife and mother for our brother Paul and his family. She assisted Paul with his health concerns and provided well for her family. After her absence, Paul's health markedly declined, and he died. We as a family believe he'd have lived a longer life and more fruitful life if she was still present. Her son Christian has had to make significant work changes as a result, as to help his family. Our family, in addition, has felt a significant loss from her absence, from her loving presence. She was an integral part of our unit. The community has felt a significant loss, and conclusively, many have had an adverse effect from her absence, from a noticeable decline in morale and mental health in many. I've noticed this from my present work in the mental health field. She impacted even more residents than we had known, learning so after her death. I would recommend 30 years for him before being eligible for parole. Thank you for your help in this matter. This statement is from Socorro, who was Nohema's sister. Your Honor and members of this court, this is not a good situation, nor your position. Even though I don't know you, I pray for you. As a Mexican, you come to this country and try your best. I know my sister did. I know this because when I attended her memorial, I listened to what the community had to say about her, her students, and all the people that knew her. They all gave me the opportunity to know who my sister was. She was devoted to the people around her. She was the kind of person who would spend her time just talking to the elderly, the kind of person who would encourage fellow immigrants that felt lost in this country. Without a doubt, my sister was an incredible human being. I know that she always did her best. I saw it every time I visited her. She completed her master's while she was already married and with children in a country and language that was not hers. My sister loved Mexico and proudly taught the Spanish language to her students. In her class, she would show her students the many different faces that the Mexican culture has, the way she would inspire her students to visit Mexico. She was a great neighbor, friend, and sister. She would help the Latin community to not give up and to always try their best. She was loved by anyone who knew her. She was very spiritual and respectful of all other religions. I think that your country has also lost a wonderful human being, a woman who transmitted peace, love, and respect. Dear Judge, I hope that you take all the arguments into consideration and come to a just sentence.
Judge, the final victim impact statement is Christian Graber, who was the son of the man.
First, I'd like to thank all of you for giving me the opportunity to speak. I thought a lot about what I was going to say in this moment. Mostly, I want to think about what my mother would want. And as you all know, my mother loved everybody. That includes you. And I know she wants the best for you. Even now, I know she's praying for you. Earlier today, I met both of your sisters. I gave them a hug and I told them that there's hope for you. Because I really do believe that. We had a nice conversation. And earlier, when I learned you had a nephew, I thought about how this could impact his life. I have hope that your story can still be something positive. And then you and I had that conversation 2 Fridays ago when we sat down together. I was very happy to have that conversation with you. The reason why is because I really do believe that you feel bad for what you did, and I believe in you, and I do forgive you. So the main focus, in my opinion, is if just moving forward, you do the best you can to be the best man you can be so you can redeem yourself. Because a lot of people don't believe in you. But your family believes in you, your nephew, your sisters, your father, and I believe that you can be a good man. And so the main focus is moving forward is what could be positive from this story. And if you do the best you can to be a good man, just know that everything's going to be okay.
Judge, that completes the victim impact statements. Thank you.
At this time, the court will pronounce judgment on the defendant. Mr. Goodale, based on your plea of guilty entered on the 18th day of April 2023, it is a finding of this court that you are guilty and are now ordered, adjudged, and decreed guilty of the crime of murder in the first degree. That's a violation of Iowa Code Sections 701 or 707.1 and 707.21a. Mr. Goodale, I've considered all the sentencing options provided for in the Iowa Code, and my judgment relative to sentence is based on the factors that your attorney and the state's attorney and these last 2 days we've been talking about. But your rehabilitation certainly is paramount for that, and at the same time protecting the community from further offenses by you and others is also what a judge does. And I have considered not just the brutal nature of the offense, but also the pre-sentence investigation and the minutes of testimony in this case, along with the entire court file, the plea agreement that you and your attorneys reach with the state, along with all the juvenile sentencing factors that I'm required to make specific findings on when we're sentencing a juvenile to a first-degree murder. It's a Class A felony. And the findings that your attorney and the state's attorney have gone through, I'll go with you after I tell you. First, I am going to order that you pay restitution joint and severally pursuant to Iowa Code Section 9103B, $150,000 to the estate of Nohema Graber and or her heirs. That's jointly and severally liable with Willard Miller. I will also order the restitution that the state has requested regarding the Jefferson County auditor. But I do find, based on your affidavit, and I did review your financial affidavit, that you do not have the ability to reimburse the state of Iowa for Category B restitution. And because of that, Mr. Molding or Mr. Brown, I don't know if you have a position on this. I don't know if I can order the crime victim assistance if I make that finding. I think that qualifies as Category B restitution.
I think you're right at this point, Judge.
Okay.
That is correct.
So I'll just order the restitution joint and severally that's owed to the Jefferson County Auditor. But I will give the state of Iowa 30 days to file any additional restitution statements so long as they do not qualify as Category B. You are ordered to submit to a DNA sample, as this is a felony offense. And pursuant to Iowa Code Section 90159A and B, I am required to announce publicly that any non-mandatory term of incarceration may be reduced because of statutory good conduct time, work credits, program credits, and you may be eligible for parole before your sentence is discharged. I am ordering that you serve the life sentence. You'll get credit for all time served on that. Going through the factors that I'm required to, I've considered the impact on each victim as defined in Iowa Code Section 915.10 and the use of victim impact statements. And I will note that your counsel has filed a sentencing memorandum, which I did read, and they cited State v. Roby, which is 897 Northwest 2nd, 127, Iowa, 2017, and State v. Lyle, which is 854 Northwest 2nd, 378. And that's an Iowa 2014 case. And the argument from your counsel is that individualized juvenile sentencing generally serves to mitigate punishment, not aggravate punishment. And I have found several mitigating factors in this case, but it's the court's belief that Iowa Code Section 902.122 does not prohibit me from considering aggravating factors. And in fact, I think I'm required under the law to consider all relevant and permissible sentencing factors. So with respect to the impact on victims in this case, I think this is an aggravating factor because you participated in a plan with Mr. Miller to kill Nohema Graber, and your actions led or helped lead to her death. The victim impact statements remind us all of the pain that the family of Nohema Graber will carry with him and the huge void that she's left behind. I'll also say that with regard to the Lyle case, and I know Mr. Goodale, this is not, I mean, this is lawyer, I'm talking lawyer talk, but even if the Lyle factors are generally more mitigating in a typical juvenile murder case, I do not find this to be a typical juvenile murder case. This is beyond the pale. With respect to factor number B, or letter B, the impact of the offense on the community, it's clear that Fairfield is a tight-knit, close community, and the entire community was shaken by your actions, Mr. Goodale, and your co-defendant's actions, Mr. Miller. So I do find that to be an aggravating factor that requires accountability. The next factor, the threat of safety to the public or individual posed by the defendant. Again, I think this is an aggravating factor, as any individual, regardless of age, who could be persuaded by another classmate to kill his teacher is a danger to the community and will require significant rehabilitation. The degree of participation in the murder by you, Mr. Goodale, is the next factor. And I find that you knowingly participated in the murder of Nohema Graber, and by your own admissions, hit the victim with a baseball bat 5 times using lethal force. While Mr. Miller concocted the plan, without your help, the execution of that plan would not have occurred. So I find this as an aggravating factor, and I don't think you have the same culpability as Mr. Miller. I think it's less, but still, without your help, he couldn't have done it. The nature of the offense is heinous, as you can imagine. It's a significant aggravating factor. Ms. Graber was killed in a brutal fashion by 2 of her own students. This murder requires the defendant serve a prison sentence for deterrence of the entire community, not just the defendant. And for context, I think it's important to distinguish some of the facts from this case involving you and Willard Miller to Miller versus Alabama, which is the U.S. Supreme Court case that Dr. Cunningham is brought in to testify about, and what we've had this last 2 days of hearing. The reason for the individualized Miller sentencing hearing is because while juveniles are different than adults, each juvenile and his or her acts are inherently different. So I don't think, I am not comparing you just to a lump of Miller, of defendants that have had Miller hearings. Miller versus Alabama involved a 14-year-old defendant who assisted another juvenile in a robbery that resulted in a shooting. The defendant in Miller versus Alabama did not fire a gun or swing a bat. In a 6-3 decision, the United States Supreme Court found that the 8th Amendment ban on cruel and unusual punishment prevented automatic life without parole sentences for juvenile offenders. That's why we're having this hearing. And subsequent 4-3 Iowa Supreme Court cases went further to take away the district court's ability to sentence a murderer under 18 to life without parole. So in spite of the mitigating factors presented by your defense through Dr. Cunningham, other testimony, and presentation of evidence and argument, the court finds a prison sentence and a mandatory minimum is required for deterrence for the defendant and others from committing murder in the first degree. As U.S. Supreme Court Chief Justice Roberts wrote in his Miller dissent, our 8th Amendment cases have also said that we should take guidance from evolving standards of decency that mark the progress of a maturing society. Mercy toward the guilty can be a form of decency, and a maturing society may abandon harsh punishments that it comes to view as unnecessary or unjust. But decency is not the same as leniency. A decent society protects the innocent from violence. A mature society may determine that this requires removing those guilty of the most heinous murders from its midst, both as protection for its other members and as a concrete expression of its standards of decency. As judges, we have no basis for deciding that progress toward greater decency can move only in the direction of easing sanctions of the guilty. With respect to your remorse, Mr. Goodale, and unlike your co-defendant, it's clear to me that you have regretted this role in Ms. Graber's murder. You've been remorseful for these proceedings, and this is a mitigating factor. Factor G is your acceptance of responsibility. This is another mitigating factor, Mr. Goodale. You pled guilty to first-degree murder and acknowledged your actions. While you certainly have the right to exercise your constitutional rights to trial, to a jury, in a different place, like Mr. Miller, by pleading guilty, you spared the defendant's family, witnesses, and community a traumatic trial. And while these Miller sentencings itself are emotionally draining for all involved, and I doubt either Supreme Court's spent much time thinking about that toll before ordering us to do hundreds of these hearings, the U.S. Supreme Court requires them. You're entitled to it. And I certainly am required to do my job, and your attorneys have done their job very well in presenting evidence. Regarding the severity of the offense, which is factor H, including any of the following: the commission of the murder while participating in another felony, a number of victims, and the heinous, brutal, cruel matter of murder, including whether the murder was the result of torture. I mentioned the offense is heinous, unusually heinous and cruel, by stalking Ms. Graber and repeatedly hitting her with a bat. Again, I'm required to find that aggravating as a factor. There's one murder victim here, but many have felt the lasting effects, including yourself, of your actions and Mr. Miller's actions. Regarding your capacity to appreciate the criminality of your conduct, I am required, and I do consider your mature and developing brain in this sentencing hearing, required by the U.S. Supreme Court and the Iowa Supreme Court. The defendant agreed to participate in a plan Mr. Miller and Mr. Goodale did to kill Nohema Graber, and this willful and premeditated murder is what resulted. You were 16 years old, and the law treats you as an adult for the purposes of prosecution, but as not as an adult for sentencing. And you have expressed genuine remorse that I did not see from your co-defendant. And this factor and the capacity to appreciate the criminality of your conduct, I think, is a mitigating factor. You stated that you never thought about the consequences. And I believe you when you say that, when you agreed to help Willard Miller kill Miss Nohema Graber. The next factor is whether the ability to conform with the defendant's conduct with the requirements of law was substantially impaired. And you didn't have any prior referrals to juvenile court services. And certainly your mother's abandoning you and your family at a young age could have resulted in youthful misbehavior. It's not clear to me if you were under the influence or impaired when the murder was committed, though you were using marijuana. And I find this as a mixed factor, but generally a mitigating factor. And then going to the level of maturity of you, Mr. Goodale, again, I think this is a mitigating factor based on the evidence presented. While you were older than Mr. Miller, and it was clear to me that you were not more mature than him, and that Mr. Miller was far more sinister in his planning and the execution of this crime. Both the United States Supreme Court and the Iowa Supreme Court have held that juveniles are constitutionally different from adults for the purposes of sentencing, and that's Miller versus Alabama and State versus Sweet, 879 Northwest 2D 811. That's an Iowa 2016 case. Mr. Goodale, you do not fully appreciate the consequences of your actions, but the analysis of maturity does not end there. While you were naive and immature, you aided Mr. Miller in murdering Nohema Graber. As everybody talked about, you knew the difference between right and wrong. You were a bright student and still are a bright individual. And you could have stopped this from happening, and you know that. And that's probably going to be the hardest thing for you to live with. Regarding the next factor, which is the intellectual and mental capacity of the defendant, I think this is a mitigating factor. Your youth and lack of fully formed brain limited your capacity to appreciate the consequences of your acts. And while you were a very bright 16-and-a-half-year-old and without a history of violence, I do find that to be mitigating. With respect to the nature and the extent of any prior juvenile delinquency or criminal history, I think this is a mitigating factor because I don't, no evidence that to my knowledge there was a previous criminal history, and you are a good candidate for rehabilitation. And I think time will tell, but you'll be far more successful than Mr. Miller. The mental health history of the defendant, and I didn't know about this until I read Dr. Cunningham's report of an undiagnosed ADHD and marijuana abuse in that 72-page evaluation. And prior to the report, I was unaware that undiagnosed mental health may have affected this crime. But this was the first criminal offense you were adjudicated for, so I think that is a mitigating factor. The next factor, which is letter O, is the level of compulsion, duress, or influence exerted upon the defendant, but not to such extent as to constitute a defense. So this is a mitigating factor to the extent that co-defendant Willard Miller influenced you to commit this crime. However, you could have notified law enforcement anytime during the planning stages. Mr. Miller did not threaten you if you didn't assist him. You weren't protecting yourself in doing this. And certainly, it's not a defense to assert peer pressure as why a defendant commits first-degree murder. So while there's mitigation in this factor, there's also some aggravation as well. Letter P is the likelihood of the commission of further offenses by the defendant. And while there's no precise algorithm in determining whether you're going to commit any further offenses, Mr. Goodale, when you're released from incarceration, I do hope that you'll have time to reflect on your actions and grow as a person in prison, and I don't think there will be any other choice for you. And I said earlier, you're a good candidate for rehabilitation, and you appear generally remorseful for this terrible act, which is refreshing compared to the last sentencing, though it's just brutal for everybody to have to hear about this again. It really is, for everybody. Q is the chronological age of the defendant and the features of youth, including immaturity, impetuosity, and the failure to appreciate risks and consequences. This is a mitigating factor, that you were a minor when you committed this crime. The law treats you as an adult for the prosecution, but I am to consider your immaturity and failure to appreciate risks and consequences in determining your appropriate sentence. You didn't appreciate the consequences of your actions, but that does not bring Nohema Graber back here. And your age and remorse are actually, I thought they would be less a comfort to Ms. Graber's family, but it appears that it is of some comfort, at least to some. With regard to the family and home environment, with your circumstances, Mr. Goodale, and again before this week, I didn't really know much about that. Certainly your home life was not the same since your mother left. While you have a complicated relationship with your father, he does care for you, and so do your siblings. Your home life may have been atypical, but you were not a troublemaker prior to the tragic events of November 2nd, 2021. I find this to be a mitigating factor. Letter S is the circumstances of the murder, including the extent the defendant's participation and the conduct and way familial and peer pressure may have affected the defendant. This is a mitigating factor to the extent Mr. Miller was the driving force behind the murder of Ms. Graber. But as I said earlier, Mr. Miller couldn't have done this without you, Mr. Goodale. There's no family influence on the murder. In a perverse way, you did feel, but this was not cheating on a math test. This was the premeditated murder of a human being because Mr. Miller did not like his grade. Letter T has me consider the competencies associated with youth, including but not limited to the defendant's inability to deal with peace officers or the prosecution or the defendant's incapacity to assist the defense attorney in defendant's defense. This is a mitigating factor due to your lack of prior contact to law enforcement. And I will say that you were represented by experienced and talented attorneys who zealously advocated for your rights. Say the statement about the state just to keep it fair, but in considering that factor, certainly you had the benefit of excellent legal representation. The possibility of rehabilitation is a significant mitigating factor. You're a very good candidate for rehabilitation. While incarcerated, you'll be able to take advantage of the programming and education in the Iowa prison systems. When paroled, hopefully you have the skills to be a productive and law-abiding member of society. Based on the record of this case and of the record of Mr. Miller's case, because I learned somewhat about you in that case as well, and then the evidence presented on your behalf here and at other hearings. Letter V is any information considered relevant by the sentencing court. And as I've stated, the U.S. and Iowa Constitution treats juveniles differently than adults in sentencing. I think this was mentioned earlier, but if you had helped Mr. Miller 18 months later, you'd be in prison for the rest of your life. So hope that is not lost either. I believe the bedrock of our criminal justice system remains the same, and it's deterrence and rehabilitation. I've considered your youth and developing brain, along with your intent and actions, which I think were cruel. In State v. Majors, which is a 2020 Iowa Supreme Court case, 940 Northwest 2nd, 372, Iowa Supreme Court Justice Waterman wrote that, quote, "Our earlier opinions have been criticized for running the risk of making it difficult, if not practically impossible, for a sentencing judge to ever impose a minimum term of incarceration. Yet, as we indicated in Roby, mandatory minimum sentences are permissible. While there is a presumption against mandatory terms of incarceration for juvenile offenders, we have expressly upheld, even commanded, their use if the court concludes that sentence is warranted after consideration of the factors." And Mr. Goodale, I believe because sentencing judges are in a unique position to deter homicidal and other violent behavior, while it may seem natural for a judge from Iowa to punt, in this case to the parole board, I don't think the parole board is adequate in its function that I have and the obligation and the oath that I take to protect the community. And I believe judges at the district court level and the trial court level are much better positioned to order criminal sentences than the parole board. Court finds, based on the nature and circumstances of this offense, along with the 25 required factors I'm required to consider in sentencing a juvenile for first-degree murder, the defendants shall be sentenced to life with the possibility of parole after 25 years. This sentence is permissible under current Iowa law. The presumption against mandatory minimum sentences has been rebutted by the nature of circumstances of this case, and it represents the appropriate time of incarceration based on the defendant's premeditated murder. Count 2 of this case will be dismissed pursuant to plea agreement. Mr. Goodale, do you agree to pay the dismissal costs on the conspiracy charge? The Iowa Medical and Classification Center in Oakdale is designated as a reception center to which you're to be delivered by the Sheriff of Jefferson County. or his designee. Again, you're given all credit for time served on this charge, including any juvenile detention center time. You do have the right to appeal your guilty plea. Your attorney must file a written notice within 30 days, and a plea of guilty is subject to a showing of good cause pursuant to Iowa Code Section 81429, and then the appellate courts will determine whether your application is granted. If you're just appealing the sentence I've just imposed and not the guilty plea, your attorneys must file that notice of appeal within 30 days, serve the written notice of that appeal upon the county attorney, and file the same with the clerk of court, together with evidence of such service upon the county attorney, and you must promptly mail or deliver an informational copy to the Iowa Attorney General. The service and the filing of a written notice of the appeal in the time and manner just specified is jurisdictional, and a failure to comply with such requirement shall be deemed a voluntary waiver by you of your right to appeal. You may be entitled to court-appointed counsel to represent you on an appeal, Mr. Goodale, in preparation of a transcript of the proceedings that we've had in this court at state expense. Judgment accordingly, minimus accordingly, bond and appeal is hereby fixed the amount, no bond. Counsel, do we need to make a record on anything else?
Nothing else I can think of, Judge.
Wish you luck, Mr. Goodale, and I hope everybody else in this room can heal as well. We'll close the record.